Dismissed.
Authorized. Okay.
Item number 1.
Your Lordship, item number 12, Your Lordship. I have seen the office report, Your Lordship. As per office on dated 27 for Your Lordship, the service is still awaited, Your Lordship. I need a
Respondent number 2.
yes, Your Lordship.
Service report of respondent number 2 is awaited. List this matter on.
Oblige, Your Lordship.
May I please, Your Lordship? My lord, regarding item number 2020, my lord, in this case, LCR has been called for, that is received. But my lord, it should be listed for admission, but it is listed in orders column along with other 2 matters, my lord. I have gone through the record, that 2 matters is totally different. Item number 19 is NI Act.
Maybe the other side has requested to list it with these 2 matters.
In the record, totally different matter. Maybe wrongly listed with our
Okay.
cases. But maybe segregated and listed, our case may be listed for admission, my lord.
We have the LCR.
LCR in our case, my lord, not in
And
their.
the other parties are present.
Yes, my lord. Service is complete. Service is complete. In my case, item number 20.
Learned Counsel, Mr.
T. Sheikh, my lord.
T. Sheikh is present and has submitted that pleadings are complete. List this matter in the admission column
Yes, my lord.
as the LCR is before us.
Yes, my lord.
Trial court records are as the trial court records are before us.
2020.
আহিছেন TCR কিন্তু ইয়াত নাই. This matter is to be segregated
Yes, my lord.
from criminal petition 520 of 2025.
My lord, LCR shown in item number 21. That LCR is in our case, item number 20. It is wrongly listed. One case from.
Yours is 513.
Yes, my lord. 513, my case, my lord. Item number 21 is from Kamrup Metro. And item number 19 is from Nagaon, my lord. And our case is from Sribhumi, my lord.
Okay, we have segregated it.
Yes, my lord. Highly obliged, my lord.
Let it come in the usual course.
My lord.
Let it come in the usual course.
My lord, usual course teacher, my lord. He is a teacher, my lord.
No. In
Yes. My
Let
lord.
it come
My lord.
serially.
My lord. That will be better.
22 এনে লিখি থৈ দিয়া পাছত দৰকাৰ পৰিলে হেৰি কৰিম.
My lord. Highly obliged.
Please, Your Lordship.
Okay.
Item number 16.
Yes, item number 16.
16. We took the consent of the opposite party. We are going to file affidavit and reply. We need some
Learned Counsel, Mr.
E. Rajkwa
A. Rasko on behalf of Learned Counsel, Mr.
and Nath and Talukdar.
And that with the consent of the other side has prayed for adjournment to file affidavit in reply.
Let it be fixed on after 2 weeks.
List the matter after 2 weeks.
Much obliged.
My lord, I beg to mention item number 27. Kindly pass over the matter for the day.
For the day. Your name?
R. Islam.
Learned Counsel, Mr. R. Islam.
R. Islam.
R. Islam.
On behalf of A. Hawari.
On behalf of Learned Counsel, Mr.
A. Hawari.
A.
A. Hawari.
Hawari has made a request to pass over the matter for the day.
May I please, Your Lordship? This is a regular bail application and pertains to section 6 of PROCEEDINGS Act.
You need
Along
to
with
notice.
Notification case there, my lord.
Learned Counsel, Miss
S. Chanda.
S. Chanda is present and learned present for the petitioner and learned additional PP, Mr. KK Parashar is present for the respondent state. Stop petitioner to take steps to issue notice to the respondent number 2 returnable on. Meanwhile, call for a investigation or Sasi has been submitted.
No. CD.
Meanwhile, call for the CD
5th of June. No?
on 5th June.
Item 2.
It is a POCSO matter, subsequent places.
Learned Counsel, Mr.
A. Mondal.
AA Mondal is present for the petitioner and learned additional PP, Mr. KK Parashar is present for the respondent state. Stop petitioner to take steps to issue notice to the respondent number 2 returnable on
8 June.
Meanwhile, call for the scan copies of the trial court records along with the scan copies of the CD on 8 June.
Objection.
Item 3.
Wait, please, your lordship. My lord, may kindly see the FIR, page, my lord, 15. My lord, this FIR is lodged by my lord, one police officer, my lord, SI Vishal Barman. My lord, after inquiry, he found some, my lord, LPG gas cylinder in possession of the petitioner. And
Under which
lordship,
sections?
my lord,
Under
It-
which sections? BNS sections or any other?
yes, my lord, that is the case, my lord.
Any other act?
No,
Special act?
and this section are not
BNS
attached.
sections.
Lordship, may kindly see
How many
page,
days you are behind bars?
my lord, 8 days, my lord. 8.
8 days. How many cylinders?
My lord, it is, my lord, there is a, my lord, schedule is 74 cylinder, my lord.
Okay,
And
let us call for a CD.
all cylinder, my lord,
Only 2 weeks time. Let us call for the CD.
my lord, kindly little
8 days
early, my lord.
early.
Early date, my lord, before, if possible, 25 or 26, my lord.
26 not.
Aju.
Haju, my lord. also.
Adu,
Let it be
today
tried, my lord.
19, my lord.
Let it be tried before, my lord, 27, my lord. Eid is there, my lord,
Haju.
that's it.
27 is holiday.
Yeah.
19, 8 days. 27.
27 is holiday.
27 is a holiday.
No, Eid is there, before Eid I am saying, my lord,
No.
25 or
It
20.
won't come. On 25 days. it will-
Haju, my lord, Haju only, my lord.
Call for the CD, list them at around 26.
No, oblige.
Matt be lordship.
Oh.
My lord, FIR is at page lordship 10 lordship. Now, my lord, petitioners, my lord, the father, sons, my lord, all the family members, 3 persons have been arrested, lordship. They were, my lord, qualified, my lord, one police, my lord, to the police station saying that the negotiation, my lord, between my lord engineer and my lord APDCL engineer, lordship, will be happen, lordship, at rupees 10,000 was called, my lord, demanded, my lord, we denied, lordship. Electric connection is there, my lord, allegation that we, my lord, misuse the connection, lordship. Actually, kindly see, lordship, the FIR at page 10, lordship. There was argument, lordship, they did not identify themselves that they were, my lord, employees of the APDCL, my lord. Argument saying, demanded rupees,
Chapter of electricity.
sorry, lordship.
Chapter of electricity.
Yes, lordship.
Under Electricity Act.
Yes, lordship.
AB or BA?
130, BA, lordship. 135, lordship. 24 days, lordship, already in judicial family members, all, my lord. The electric connection is there, lordship. The prepaid meters are, the smart meters are there, lordship.
Yes.
My lord, lordship, may kindly, my lord, see, my lord, page number 10, my lord, this is FIR, my lord. Page number 10, my lord, lordship, may kindly come to 3rd paragraph, my lord. During the inspection, it was found that the consumer was illegally using electricity through bypassing several service cables in his premises, having consumer number so and so, consumer name Tosif Hussain, meter number so and so, violating section 135 of the Electricity Act 2003. Also, it was found that a commercial enterprises was illegally running from the domestic meter in his premises, which is an act of violation of category. While our staff attempted to disconnect the illegal connection and tried to seize materials as per procedure, Joinal Abedin and his son Tanvir Hussain, Tokrif Hussain and Tonsif Hussain abused, threatened and physically manhandled the team and the members, my lord. So that is why, my lord, this FIR was registered, my lord, under section 126, 132, 303 and 35 of the BNS, my lord, reduce section 135 of the Electricity Act, my lord. So let the case diary may be called for, my
Now,
lord.
my
What are the
lord,
allegation in the, my lord?
For a moment, lordship, kindly see
FIR,
page 22, lordship.
Custodial detention is not required.
Lordship may fix a sorted, my lord, we will produce the case diary. If we fail to
Not
produce the
necessary,
case diary,
lordship.
my lord, then lordship
My
may, my
lord,
lord.
what will be the purpose, lordship?
The purpose is, my lord, the FIR is very clear, my lord.
My lord, if any, my lord, electrical, my lord, connections here, my lord, those might be seized, lordship. My lord, in such a case, my lord, in my humble submission, custodial interrogation may not
By
be
this act, my lord.
23 days in judicial custody, lordship. My lord, father, sons, lordship. So in such a case, my lord, in all cases, my lord, CD, my lord.
No, my lord,
will
question is
not
that, my lord, if
serve
the
any
FIR,
purpose,
my lord,
lordship.
if FIR shows, my lord, they are stealing, my lord, electricity, my lord, and they are using in for commercial purposes, my lord.
No, but that is not.
No, that is, my lord, as per the FIR, my lord.
My
I'm
lord,
sorry.
kindly see the my lord, photograph at page 22, lordship. The house premises, lordship. The house premises in that, my lord, in attached, my lord,
What commercial
That,
what commercial?
my lord, electronic shop, that was not started, lordship. Kindly the trade license, trade 24, at best 24, the trade license.
Lordship may fix it on Friday, my lord.
My lord,
Project
my lord, 24,
Friday.
kindly, for a moment, kindly see, lordship. Let me submit my trade. My lord, the 23 lordship, page 23 lordship, that was issued, trade license was on for 24/4/2026. LS incident was 22, my lord, before 2 days, my lord. This, my lord, the business was not started, my lord. I admit, lordship, my lord, for the purpose of lightening, lordship, the business premises was, my lord, attached to my house, lordship. Attached to our house, my lord. For the lightening, my lord, the connection was, my lord, given, lordship. For that rupees 500,000 was demanded, lordship, from me, from the, my lord, son of the petition number 1, lordship, Tanvir. My lord, he is not arrested, lordship. Now, denied, lordship. On that grounds, my lord.
No, you see what date you are showing.
Sorry,
Starting from the date of 1/7/2025 to 30/6
Well,
2026.
Well, that was, my lord, resolution, my lord. Now issued on 24/4/2026, lordship. Once I resolution proof.
On Friday, my
Even
lord.
effect,
We'll
lordship.
produce the case on Friday, my lord.
Not even. Heard learned counsel Mr. M.H. Ahmed for the petitioners, 1, 2, 3, who have filed this application under section 483 of the BNWS 2023 with prayer for bail as they are behind bars since 25/4/2026 in connection with so and so case under so and so sections. Heard Mr. R.J. Borua, heard learned additional PP Mr. R.J. Borua for the respondent state, who has raised serious objections stating that the business enclosure attached to the petitioner's house have been using domestic power supply for business purposes. To stop the petitioner's bail petition can be considered only after perusal of the CD. To stop, the petitioners have been involved in theft of electricity and they were aggressive by nature, and they are aggressive by nature as they tried to attack the tried officials under the APDCL. Officials of the APDCL or ASCB?
PDCL Kanpur, lord.
Of the APDCL Kanpur. On the other hand, the learned counsel for the petitioner has submitted that the trade license
Lordship.
at a trade license marked as Annexure 5
Lordship.
was issued on 24/4/2026, and they were about to start their business. First off, they were not running the business at the time of the incident, and they were not involved in theft of electricity for domestic purpose and converting into industrial purpose. Full stop. I have considered the submissions at the bar with circumspection. The petitioners have been behind bars since 25/4/2026. It appears that presumably investigation may have progressed to a certain extent. It appears that further custodial detention may not be required for the progress of investigation. The petitioners are local residents and they are not flight risks. The petitioners have pledged to cooperate with the remaining part of the investigation and to abide by any stringent bail conditions if imposed upon them. Considering all aspects, the petitioners are enlarged on bail of rupees 30,000, which is suitable surety of like amount, 30,000 each, with a suitable surety of like amount to the satisfaction of the learned Laka magistrate stroke jurisdictional court. No, it is in the additional district judge court, no?
My lord, no, lordship. This is Chief Judicial
Elaka
Magistrate.
magistrate to kati diya. Jurisdictional court stroke Elaka magistrate likhi diya. Elaka magistrate.
Chief Judicial CGM Nagaon, lordship.
The condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 2, the petitioner shall refrain from such activities with which they allege, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioners.
Much of like that.
I can fight for it, sir.
LCA আছে নেকি?
This the petition for quashing the pending GR case.
Mm.
But what has happened here is that indeed a fraud has been committed. But the important thing is that fraud has been committed by the brother of the informant and one bank official for whom I am not appearing in this matter. There are total 6 accused persons.
Mm.
5 are before your lordship. 1 we are not appearing.
Mm.
He may or may not be involved. We are not for him. If your lordship comes to the complaint, page 29.
This is revision petition or
There is a quashing petition.
quashing
under
petition? Okay.
82. There is it.
Page 29.
Page 29.
Okay. चलो दूर से रहिए 10 मिनट भी रहिए.
The informant is one Diganto Kakoti Malaj.
Mm.
And if your lordship sees the names of the accused persons, there are 6 accused persons. Now, my lord, I am for my lord 2, 3, 4, 5, and 6, not for 1, my lord.
Okay.
Because my lord, the names and dates.
You are for
designation.
2, 3, 4, 5, and 6.
And 6. Yes. I am not appearing for Bipul Kumar Khatoniar.
Mm.
Well, the complaint, if the lordship permits, my lord, I'll have to read it in full.
Yes, yes.
Basically, because
You are coming for quashing this complaint, isn't it?
complaint as far as these 5 people are
Okay.
concerned, not as far as the accused number 1 is concerned. If your lordship comes to page 30, my lord.
Okay.
If I may read, my lord.
Yes.
That the complainant is a son and a legal heir of Punya Prabha Kakoti, who was the owner of a plot of land measuring 2 katha 11.5 lesser, covered by dag number so-and-so or PP number so-and-so, situated at so-and-so under Dibrugarh Moza, by way of purchase and possession by deed of conveyance, registered deed number so-and-so, serial so-and-so, dated so-and-so from Shri so-and-so, and out of which she donated a portion of land measuring 1 katha with specific boundaries to her son Sri Prasanto Kakoti by deed of gift dated 7/6/2003 for construction of his residential building. After the donation of 1 katha, she was the absolute owner of the remaining land measuring 1 katha 11.5 lechas with an Assam type residential building standing thereon. Punya Prabha Kakoti expired on 29/10/2017, leaving behind the complainant as one of her legal heirs, successors in interest. Now, next note, that Shri Prasanto Kakoti took housing loan of rupees 9 lakhs from Punjab National Bank for construction of his residential building on his aforesaid land of 1 katha, creating equitable mortgage over his own land as security for repayment, and the complainant's mother stood as personal guarantor and signed the letter of guarantee on so-and-so. At her, lordship will kindly note the date, madam. On 25/7/2003, at her
So
own.
this is not the complainant, Prasanto Kakoti?
No, Prasanto Kakoti is the own brother of the complainant.
Okay.
Own brother.
Okay.
And both of them are the sons of
Okay.
Srimati Punya Prabha Kakoti. So on 25/7/2003, at her own residence, when the accused number 1, lordship will kindly note, accused number 1 visited her residence in connection with the said loan, but the complainant's mother never mortgaged her plot of land measuring 1 katha 11.5 lesa against the housing loan sanctioned to and availed by her son, Sri Prasanto Kakoti. The accused number 1, Bipul Kumar Khatoniar, the then branch manager of Punjab National Bank, Dibrugarh branch, along with his accomplices, indulged into forgery and fabricated documents and had fraudulently shown the complainant's mother as mortgager of her aforesaid landed properties with her residential building in the aforesaid house building loan. Lordship, if I pause there for a minute, this starts in 2003. Precisely on 25/7/2003, when the accused number 1 was, my lord, the then branch manager of the Dibrugarh branch. Now, my lord, the important thing to note is that who has availed the loan? The person who availed the loan is Prasanto Kakoti, brother of the informant. The documents, mortgage documents were signed at the house. That is as per, I'm going by the complaint, I'm not saying anything from myself. As per the complaint, documents were signed at the house of the proposed guarantor, Srimati Punya Prabha Kakoti. Punya Prabha and Prasanto are my lord's mother and son. So the loan is taken by Prasanto Kakoti, guaranteed by Punya Prabha Kakoti, and the bank manager who has apparently executed or helped in the execution or sanctioned is accused number 1, Bipul Khatunia. So this is how things stand as of 2003. This is the first loan. Now, if your lordship comes, is the next paragraph. That subsequently the said bank sanctioned other loans to Sri Prasanto Kakoti, viz. Housing loan of rupees 9 lakhs, enhancing from outstanding balance of previous house building loan rupees so and so and overdraft loan of so and so on 8/11/2005. Again, my lordship will kindly note the date 8/11/2005. And transport loan of rupees 33 lakh 24,000 on 22/2/2006. And one loan of rupees 4 lakh 50,000 even in the name of the complainant's mother and her daughter-in-law, Mona Lisa Kakoti, wife of Sri Prasanto Kakoti, jointly on 21/5/2004. For renovation of the complainant's mother's residential building without knowledge and consent of the complainant's mother, and the bank forged complainant's mother's signatures on all loan documents, including the documents showing continuation of mortgage of complainant's mother's land fraudulently in all loans, sanctioned to Sri Prasanto Kakoti, and thereby committed forgery, personation for cheating, and deceitfully depriving the complainant's mother from her immovable properties shown to have mortgaged as security for the repayment of the loan sanctioned to and availed by Sri Prasanto Kakoti, as well as in the name of the complainant's mother herself, jointly with Mona Lisa Kakoti. So, my lord, all in all, there were 3 loans. First, there was a house building loan of 9 lakhs. That was in 25/7/2003. Then, my lords, on 2008/11/2005, the house building loan was somewhat enhanced, my lord. And there was an OD loan, overdraft loan also, 2,25,000 on 8/11/2005. This is the second loan. Third loan is transport loan, my lord, 33 lakhs 24,000 taken on 22/2/2006. And one loan of 4 lakh 50,000. I don't know why this loan has been included. It has nothing to do with these proceedings. Anyway, my lord, that loan of 4 lakh 50,000 is said to have been taken on 21/5/2004. So 2003, 2004, 2005, 2006. Or everything has happened in those 3-4 years. Now, my lord, if your lordship comes to the accusations against the present petitioners, my lord, para 4. That the accused number 2, Sri S.K. Sinha, he is petitioner number 1 in this petition, without ascertaining the liability of the complainant's mother as guarantors in respect of her landed properties, measuring so-and-so, covered by dag number so-and-so, patta number so-and-so, under Dibrugarh Moza, against the loans sanctioned to and availed by Sri Prasanto Kakoti, illegally wrote to the Deputy Commissioner, Dibrugarh District, via his letter dated 27/7/2011, by sheer misusing the power, jurisdiction, and authority under the provisions of the Sarfesai Act for taking possession of the aforesaid landed properties of the complainant's mother, whereas she never mortgaged her any property nor stood as guarantor in the loan sanctioned and disbursed to Sri Prasanto Kakoti on 8/11/2005, 12/11/2005, and 28/2/2006. As far as accused number 2, that is petitioner number 1, Sunil Kumar Sinha, is concerned, this is the accusation that in 2011, he wrote a letter to the DC for taking physical possession under the Sarfesai Act, not in 2003, 4, 5, 6. This is the only specific allegation against the petitioner number 1. Now, further it says, one line, the accused number 2 used forged, fraudulent, and concocted documents by the bank officials for deceitfully depriving the complainant's mother from her immovable properties. Now, even in this paragraph, lordship will note that the loans sanctioned and disbursed to Sri Prasanto Kakoti on 8/11/2005, 12/11/2005, and 28/2/2006. So, loans are availed in 5 and 6. And Mr. Sinha has written the letter to the DC under Sarfesai Act in 2011. That is the accusation against him. Only accusation. Now, if your lordship comes to the next paragraph, that the Punjab National Bank filed a case being debt recovery case number 179 of 2013, the plaint of which was signed and verified with an affidavit by the accused number 3, Sri Prashant Kumar Dwivedi, with forged and fraudulent documents in support of the case in the DRT Gauhati versus Prasanto Kakoti and 3 others, including the complainant's mother, as one of the defendants, praying for grant of reliefs among others for recovery of rupees 41 lakh so-and-so inclusive of interest, and the mortgage security as detailed in schedule herein below be ordered to be sold. Now, if your lordship if I may just elaborate what is the specific allegation here, Lordship will kindly have page 66, my lord, of this petition only. What is the allegation against the petitioner number 2, my lord? Prashant Kumar Dwivedi. Lordship will kindly have page 66. Here is the copy of the OA, my lord, the debt recovery case, which was filed by the bank, my lord. And if your lordship sees at page 90, Prashant
This is
Kumar,
accused number 2, no?
he is accused number
Three.
3, my lords, but petitioner number 2
Okay.
here. Lordship will find at page 90, he has signed the plaintiff and he has filed the affidavit. Page number 90. my lords. Yes,
He has signed the affidavit.
He has signed the affidavit in the court case, ma'am, for effectively, my lord, recovery of money against the brother of the informant, his mother and all. So this, my lord, if your lordship notes, this was done on 25/9/2013, my lords. So this is the accusation, my lords, against
Yes.
the petitioner number 2. Now, if your lordship comes to the next page, my lord, because others are only the loan details, I'm not going into that, my lord, not necessary. Page 33, para 6. That the complainant's mother contested the DRT case number so-and-so by filing a written statement denying of creating mortgage over a landed properties at any time. She also alleged commission of forgery by the bank in respect of all documents pertaining to creation and continuation of mortgage by her. The accused number 4, Mr. P.T. Namgyal, adduced his evidence and additional evidence on affidavit and exhibited the documents, including the forged documents in support of the bank's case and false claims against the complainant's mother. Honorable DRT was pleased to send the alleged forged documents bearing signatures of the complainant's mother to CFSL for examination by handwriting expert and furnishing report. The report and opinion with reasons for the opinion on examination of disputed documents by Shri so-and-so was sent by number so-and-so dated 24/9/2015 to the Debt Recovery Tribunal. As per expert opinion of CFSL, all the documents, that is exhibits number A12, A14 and A17 of the bank by which the complainant's mother was alleged to have created mortgage in respect of loans were found forged. All these exhibited documents, lordship will kindly note this line. All these exhibited documents were forged during the period when the accused number 1 was working as the branch manager of Punjab National Bank Dibrugarh branch and sanctioned the loans and loan agreements documents were made. This is the specific allegation against accused number 1, my lords, with which I am not concerned. The bank also failed to produce any document executed by the complainant's mother creating equitable mortgage in the first housing loan of ₹9 lakh sanctioned to Sri Prasanto Kakoti on 26/7/2003. But the Honorable Tribunal held to have created equitable mortgage only because the original title deed was with the bank. Unfortunately, complainant's mother expired on 29/10/2017 and the Honorable DRT delivered a judgment in DRT case number so-and-so on 31/10/17, holding that since the liability of the defendant number 2 is only for housing loan account, hence the applicant bank is directed to file revised statement of account showing separate liability of the defendant number 2. So the DRT holds, I'll read the judgment, that part, that only the first loan of 9 lakhs valid mortgage has been created by the mother. The other extension, further loans, she has not signed the documents. That is the judgment of the DRT. That has attained finality, if I may say so. Now, if your lordship comes, but we were into the accusations against petitioner number 5, P.T. Namgyal. Now, if your lordship comes to the next page, para 7, some more allegations are there against P.T. Namgyal. That the Punjab National Bank also filed title suit number 79 of 2014, the plaint of which was signed and verified by the accused number 4, Mr. P.T. Namgyal, as Chief Manager, Dibrugarh Branch, supported by an affidavit relying on forged and fraudulent documents against Punya Prabha Kakoti and 2 others, with so-and-so, in the court of the civil judge Dibrugarh, praying for grant of reliefs. So the accusation is that the bank has filed a plaint and that plaint has been signed and the documents has been exhibited
Page
by
37.
lordship.
Which page? Page 37.
Page 34,
34. Okay.
I was just reading page 34, para 7. Lordship, have it?
Yes, yes.
Yes, if I may read again. Para 7.
Not required.
Lordship. Now,
He has only signed the plaint.
he has only signed a plaint. Now, if your lordship, if I may just be very specific, lordship will kindly have page 91. Page 91, my lords, is the basis of the accusation against petitioner number 5, P.T. Namgyal. He has signed the evidence on affidavit in the DRT case. page 91 onwards. And that he has done, my lord, if your lordship sees the date, that is 29th August 2014. So, this is the accusation against the petitioner number 5. Now, your lordship comes, my lord, we have seen the accusations as to some of the accused, now the others. Now, if your lordship may kindly have page 37.
Yes.
Para 12. That documents with exhibit number A12, A14 and A17 produced and exhibited by the Punjab National Bank in DRT case number so-and-so pertaining to standing guarantor and creation of equitable mortgage over the landed properties of the complainant's mother as security against the housing loans, overdraft and transport loan availed by Sri Prasanto Kakoti were forged documents created by the accused persons for the purpose of cheating and the accused persons using the same as genuine in the judicial proceeding. Lordship will kindly note, accused persons use the same as a genuine in the judicial proceeding. Then it proceeds to say, thus the accused persons committed the offences punishable under section so and so. Half the IPC has been reproduced here. So anyway, let us move to the para 13. That the accused persons have also forged all the documents with loan application of Punya Prabha Kakoti dated 2404, joint loan application of Punya Prabha Kakoti and Monalisha Kakoti dated 2004-2004, agreement of housing loan of ₹10, consent clause of borrower, letter of authority, letter of borrower dated 4/6/2004, balance and security letter dated 31/12/2006, letter of continuity dated 10th May 2004, produced and submitted in support of the plaintiff's claim in title suit number 79 of 2014 pertaining to the loan for residential building renovation so and so. The title suit number 31 of 2015 and miscellaneous case number 35 of 2015 filed by the complainant's mother in the court of the civil judge at Dibrugarh are pending adjudication. Well, they are still pending adjudication even today also. But be that as it may, Lordship will note in these paragraphs that all the documents are 2004-2006. Not a single document pertains to the later period. Now, if a Lordship comes to para 14, that the accused persons criminally conspired to cheat by way of forging the documents and deprive the complainant's mother from her valuable landed properties in spite of her denial of having mortgaged her properties as security in any of the loans availed by Sri Prasanto Kakoti and also of applying and availing any loan by herself for renovation of her residential building. The accused persons representing the Punjab National Bank in different times and capacities illegally put the aforesaid landed properties of the complainant's mother into e-auction, while notice dated 23/2/2015 published in an Assamese daily Doinik Ahom dated 25/2/2015 fixing base price so and so, claiming that complainant's mother stood guarantor in all the loans availed by Sri Prasanto Kakoti without any order from the DRT Gauhati or the court of the civil judge Dibrugarh. Thus, the accused persons defamed the complainant's mother, who had a respectful in the locality as she was associated with social works and religious activities of the local Namghar, by throwing her out of her residential house in the most disgraceful manner for no fault of her, and putting her residential building to sale by the process of e-auction by publishing e-auction notice in newspapers inviting tenders from intending purchasers. The accused persons sold the complainant's mother's landed properties on e-auction to Sri Manav Jyoti Raj Khanikor. The accused number 5. No, Malot, this is the accusation regarding Malot. The petitioner number is petition number 3, Deepak Kumar Sengupta. But here he is accused number 5. D.K. Sengupta issued sale certificate dated 18/6/2015. The accused persons have committed criminal breach of trust and they have been using and utilizing the sale proceeds for their own benefits without sanction of law, and thus they have committed the offence punishable under section 409 IPC. If your lordship, as far as the allegation against the petition number 3 is concerned, turns to page 226. What is the sole allegation?
Petition number 3.
3, Malo. Deepak Kumar Sengupta. I'll give a list, Malo, that will
Page.
assist your lordship.
Page.
226, Malo. Lord, this is a sale certificate.
Okay.
because the property was auctioned under the Sarfisai Act. It was sold to one Madhav Jyoti Ras Khonikor. And this sale certificate was issued by D.K. Sengupta in his capacity, my lord, official capacity as the chief manager and authorized officer of the bank.
Okay.
And this is dated, my lord, 18th of June 2015. So this is as far as the petitioner number 3 is concerned. Now, your lordship will kindly see the next paragraph.
This is 18 June 2013.
This is 18 June 2015, my lord.
Okay.
Now, your lordship will kindly have the next paragraph. That the accused persons having sold the complainant's mother's landed properties illegally and without any sanction of law of the land under disguise of the Sarfisai Act on e-auction to Sri Manav Jyoti Ras Khonikor at an amount of 27 lakhs in the most fraudulent and deceitful manner for non-existent liability of the complainant's mother, and having issued sale certificate dated 18/6/2015 without jurisdiction and authority of law, got the land of the complainant's mother mutated first to the name of the Punjab National Bank and simultaneously to the name of the e-auction purchaser, vide order dated 29/7/2016 of the Circle of.
So after all this, you came to know that the signatures were fraud.
Yes.
Forged.
When the proceeding,
After all the procedure, you
after
came.
all the proceedings, when the my lord,
When did you learn that the signatures?
my lord, the
were-
DRT, after the my lord's,
all the procedure by the DRT.
yes, when the cross-examination was done, my lord, when the DRT gave his judgment on 31 October 2017.
Okay.
31st October 2017. So, my lord, here it says the accused persons have committed the offense under section 499 IPC punishable under so and so. That, my lord, we are not so much concerned because cognizance has not been taken regarding that. If your lordship will kindly permit, my lord, the next page. Page 39, internal page 11. That it may be mentioned that accused number 1, what you will see, accused number 1 was punished by the competent disciplinary authority of the Punjab National Bank by way of removal from the service of Punjab National Bank, having found him guilty in their disciplinary proceeding drawn against him of committing illegalities relating to sanction of various loans and execution of loan documents while he was working at Dibrugarh branch. So, my lord, accused number 1 was later dismissed from service. That is a subsequent development. And that is why, my lord, we are not for him. He may or may not have been involved. That's a different aspect of the matter. We are not for him. His actions, my lord, definitely are under a cloud. But I am for the other accused persons. Now, if your lordship comes to the, my lord's para 17, that the delay in filing this complaint is resulted due to the facts that the complainant's mother came to know about making false documents by her forged signatures and personation, using the forged documents as evidence in judicial proceedings in course of the proceeding in DRT case number so-and-so filed by the bank against Sri Prasanta Kakoti, Punyaprabha Kakoti, Pranab Jyoti Barua and Messrs. Gargo Motors, of which judgment was delivered on 31/10/2017, immediately after expiry of Punyaprabha Kakoti on 29/10/17. Later, PNB filed petition under, this is not important, I'll go to the next part. But the revised statement of account is directed the Punjab National Bank by the DRT Gauhati in the judgment for furnishing to PP Kakoti has not yet furnished so as to ascertain her liability, if any. Moreover, the title suits number 79 of 2014, 31 of 15 miscellaneous cases so and so pertaining to the fraudulent, forged and concocted documents liability are pending for adjudication in the court of the civil judge Dibrugarh. The complainant came to know about mutation of the name of the Punjab National Bank and the e-auction purchaser, Sri Manav Jyoti Raj Khonikor, in place of complainant's mother, land covered by part of Dag number so and so, situated extended Tekela Chiringao under Dibrugarh Moza, only on 10/8/18 when he applied for a certified copy of the aforesaid patta. Under the above facting circumstances, the delay so and so, this is basically the sum of the
Okay.
allegations. And as far as the petitioner number 4 is concerned,
Charge sheet has been submitted?
no, this is a complaint case.
Okay, okay.
Cognizance has been taken.
Cognizance was taken?
Cognizance has been taken only under 417, read with 34 items.
Okay, under.
We are on that limited aspect of it. Whether a case of 417 malots is made out or not. So before the
You have a stay in your favor?
yes, there is a stay. If your lordship turns, my lord, to the,
When was cognizance taken?
I'll come to that. The I had marked that page, now
It's
I'm
okay.
unable to
It's
find
okay.
it. Initially, my lord, there was an inquiry directed, page 265, there was an inquiry directed under 202. That your lordship will find at page 265. Subsequently, my lord, there was a report furnished by the police.
369.
36.
Running page 369.
Or affidavit.
Our affidavit in opposition.
Cognizance, taking cognizance.
Yes, 369. Good. Yes. Now, before 369, if your lordship will kindly have page 365. my lord. The inquiry that was conducted by the police, my lord, pursuant to the direction of the court, the inquiry under 202 CRPC, because the court thought it fit to direct a limited inquiry. Because
By
most
the
of the
police.
yes, prior to taking cognizance.
365.
365. This is the inquiry report, my lords, which was prepared by the DSP, my lords. DSP headquarters, Dibrugarh, Assam. This is addressed to the SP, Dibrugarh, my lord. Now, your memo number, inquiry report in connection with court case number 35 of 2019, Sri Diganto Kakoti versus Sri Bipul Khatoniar and others. Well, this is the limited brief of the case, my lord. Lordship has already seen, so I will not be on that, my lord. Lordship will kindly have the findings part, which are at page 367.
Okay.
Page 367. Lordship have it, my lord?
Yes.
During investigation, I have examined the complainant, Sri Diganto Kakoti, Sri Prasanto Kakoti, brother of Sri Diganto Kakoti, who is the receiver of the loan amount, Mohammad Saidur Rahman, present branch manager of the Punjab National Bank, Dibrugarh branch, and Sri Biswajit Singha, lawyer of the Punjab National Bank, and recorded their statements under section 161 CRPC. Now the findings are like this one. The PNB Dibrugarh continued the complainant's mother's properties, showing as a mortgage against loan amounting to rupees 2,25,000 and rupees 33,24,000 for sanctioning and disbursing to Sri Prasanto Kakoti without any intimation to the complainant's mother, Srimati Punya Prabha Kakoti. This is a gross lapse on the part of the Punjab National Bank Authority, Dibrugarh. The present bank manager, PNB Dibrugarh, Sri Saidur Rahman, and entrusted lawyer of the bank, Sri Biswajit Singha, are not aware of the litigation. Now, number 3, Malad. It is also learned during inquiry that all loan transactions between PNB Dibrugarh and Sri Prasanto Kakoti were held during the tenure of alleged accused number 1, Sri Bipul Khatoniar, the then bank manager, PNB Dibrugarh. As an outcome of various fraudulent activities, Sri Bipul Khatoniar, the then bank manager, PNB Dibrugarh, was punished by the competent
That
disciplinary.
loan, apart from 9 lakhs,
Lordship.
the other amount
Lordship.
that was disbursed
Yes.
in favor of, in whose account did this money?
Prasanto Kakoti.
So was he made an accused?
Now, that is the interesting part.
Okay.
Why will he make his brother accused? His brother is the main fraud. His brother and this Bipul Khatoniar conspired with each other to defraud the bank. Now, I don't know, for whatever reason, the bank, perhaps realizing that one of its own officers was involved, admittedly, my lord, perhaps Bipul Khatoniar may have been in. Yes. The bank should have filed an FIR against these two persons. The bank didn't. Normally, what happens is that this type of accounts are declared as a fraud account. FIR is filed, action that he has taken. Now, perhaps to prevent that from happening, like an anticipatory bail, we have an anticipatory complaint. He, my lord, says, my lord, you will kindly imagine for a minute. The title deeds are deposited, the signatures are taken.
It's as if the sale deed has walked, my lord, from the house of Punyaprabha Kakoti to the bank. Prasanto Kakoti has availed the loan. He is innocent. He is a saint. He is innocent and he is free. And 5 officers of the bank who were not there in Dibrugarh, who were not there even in Gauhati, 1 or 2 of them were not even in the service of the bank. They have been put into the dock here under 417. But where is the deception? Where is the inducement? There's nothing.
So what are the findings finally?
Let us go to the findings, because that will cleanse the issue. Were held during the period so as an outcome of various fraudulent activities, Sri Vipul Khatoniar was punished by the competent disciplinary authority of PNB by way of removal from the service, having found him guilty in the disciplinary proceeding drawn against him of committing illegalities relating to sanction various loans and execution of loan documents while he was working at Dibrugarh branch. The opinion of the handwriting expert of the CFSL dated 30/7/2018. I think this is wrong, Milord. It cannot be 18. It has to be 15. Because this date is wrong. Because I was there in this case. I was a lawyer. Thankfully, I was not put into the dock also. The person who wrote the blue enclosed signature stamped so-and-so and marked as so-and-so did not write the signatures in red enclosed portions, similarly stamped and marked so-and-so, which proves that the PNB authority fraudulently used the complainant's mother's signature in all relevant documents for sanctioning and availing loans to Sri Prasanto Kakoti. Now, the police also have to be given a lot of credit money. The loan is taken by Prasanto Kakoti, but it is the bank who has committed the fraud. Prasanto Kakoti has not committed the fraud. I mean, what? So these are senior officers, my lord, DSP rank. I don't know how they have become. The PNB authority during inquiry found dissatisfied with the opinion of the handwriting experts of the CFSL Gauhati. During inquiry, it is also ascertained that the Honorable DRT delivered a final judgment on 18/4/2018 in connection with case number so-and-so, holding that since the liability of the defendant number 2 is only for housing loan account, hence the applicant bank is directed to file revised statement of account so-and-so, but the bank has not yet complied with the order of the Honorable DRT, but as per version of the entrusted lawyer of PNB Dibrugarh, they have not received any communication from the Honorable DRT for separation of liability. It has, Lordship will kindly note the last paragraph. It has also been revealed during inquiry that in the DRAT Kolkata wide appeal number so-and-so, 3 appeals were filed, my lord. The appellate tribunal stated that 3 banks, viz. Punjab National Bank, UCO Bank and United Bank of India, claimed that they were the lenders of the money to one Sri Prasanto Kakoti. All the 3 banks claim that the loan has been advanced against the surety, which was in the form of creation of mortgage of the scheduled property contained in the gift deed executed by the mother of Prasanto Kakoti. Prasanto Kakoti took the gift deed, produced it before not 1 but 3 banks. Original in 1 and 2 certified copies in 2 others. That is part of the finding. I'm not going into Prasanto Kakoti's guilt because we are not concerned here with that. But Lordship will see the conduct. What has happened? He has defrauded not 1 but 3 banks. And in this act of fraud of his, one of our officers, that is the petitioner number, the accused number 1, was involved with him. And the rest of these people are unnecessarily made scapegoats, whereas they had nothing to do. They have acted in the performance of their duties. They have received the records. And after 2017 or 18, when the DRT judgment has come, which has now attained finality, that let them point out a single act that these bank officers or any other bank officer has done pursuant to in contravention of that DRT order. After those findings have come, there is none. And here, the police says that no, the bank has committed the fraud, but loan has been availed by Prasanto Kakoti. So based on this, the cognizance was taken. If your Lordship sees the next page, P69 370. Here, this is the order of 3/12/2019 against which, basically we have come. Complaint is present, produced case record. There appears sufficient ground to proceed against the accused Vipul Kumar Khatoniar, Sunil Kumar Sinha, so-and-so, for offense under section 417, 34 IPC. Hence, cognitions are there under is taken. This among so-and-so. So, this is the order that we have come against. So, all the other sections of law were dropped, and the only section of law, that was there is 417. Now, if your Lordship will kindly have, for a minute, I would like to take your Lordship to the DRT's judgment. What the DRT said. It starts at page 308. 308, my lord. This is annexure 6. Lord, the entire thing is not necessary. I will only take your lordship, my lord, to the relevant part, my lord. Now, lordship will kindly have, my lord, page 329. Not the entire record of the case and this previous surface eye proceedings, etc., they have been described. Lordship will kindly have the last line onwards. You know. From the above, it is evident that the defendant number 2, defendant number 2,
329.
Lordship, the last line.
Yes, yes.
From the above, it is evident that the defendant number 2, my lord, defendant number 2 was Punyaprabha Kakoti, my lord, the mother of the infant and the guarantor. Defendant number 2 was well aware that her property is under mortgage for the loan availed by the defendant number 1. 1 is her son, Prasanto, 2 is the mother. It is also observed that the sale deed dated 27/5, there is a typographical error here, it should be 1974, by which she had become owner of this property is with the applicant bank. So the sale deed is with the applicant bank, marked as Exhibit A3 in this application. It is observed that by gift deed dated 7/6/2003, the defendant number 2 has gifted 1 katha of land to the defendant number 1. The defendant number 2 has miserably failed to explain as to how the sale deed is in the possession of the applicant bank. It is an admitted fact that the defendant number 2 has executed and signed the guarantee deed, and in the sanction letter, plot of 2 katha 11.5 letters is required to be mortgaged. It has also come on record that the applicant bank had taken action under the Surface Eye Act 2002 and the rules made thereunder in the year 2007. And the possession has been taken in 2008, and the possession notice was published in 2 leading newspapers, and the defendant number 2 had made no challenge to the possession notice. There is no evidence on record which could show that the mortgage has not been created in the year 2003 by the defendant number 2. This is a specific finding, my lords, of the DRT, that there is nothing to say that mortgage was not created by Punyaprabha Kakoti in 2003. She did create the mortgage in 2003. By the defendant number 2. Exhibit A14 is letter for extension of mortgage dated 31/12/2005, but it has been clearly mentioned that I have already on 25/7/2003 deposited with you in your office the original title deeds of my property situated at such and such. Under details of the title deed deposited and the property recovered covered thereby, it has been mentioned that registered conveyance deed number so and so. In the case of State of Haryana versus so and so, in the case of so and so, Honorable Supreme Court has held that the question as to whether the mortgage by deposit of title deed is required to be done by instrument at all. In our opinion, it will be effected in specified term by debtor delivering to his creditor document of title to the immovable property with an intent to create security thereon. No instrument is required to be drawn for this purpose. However, the parties may choose to have memorandum prepared only showing the deposit of title deeds. From the above, it is evident that the mortgage has been created by the defendant number 2 for the loan availed by the defendant number 1. The original title deed has been deposited, which shows the intent to create the mortgage as security for the loan availed by the defendant number 1. Hence, there is a debt, deposit of title deeds, there is an intention to create mortgage as security. From the above, it is evident that the defendant number 2 had created equitable mortgage by deposit of title deed in the year 2003 for the loan of rupees 9 lakhs availed by the defendant number 1. Hence, I do not agree with the contention of the defendant number 2 that she had not created any mortgage in the year 2003 for the loan of rupees 9 lakhs availed by the defendant number 1. Now, the further question as to whether the defendant number 2 has stood as guarantor and mortgage to secure the loan, which is term loan, for purchasing 3 Tata Motors. The defendant number 2 has denied having executed and signed Exhibit A12, A4, A17. It is observed that the handwriting expert has given the opinion that the signatures on these 3 documents, Lordship will kindly note that signatures only on these 3 documents, not in all the documents.
Yes.
Are not of this person who has signed and marked as serial number 1, serial 1, S1 to S10 and A1 to A9. That is the defendant number 2. It is also observed that Sri P.T. Namgyal, the chief manager of the bank who has filed evidence, was not working in the branch when the documents were executed by the defendant number 2. He has filed evidence on the basis of the record and not from his personal knowledge. It is also observed that Exhibit A12, A14 and A17 bear short signatures as well as long signatures. It is also observed that the short signatures put on Exhibit A12, A14, A17 do not tally even to the naked named eye, it should be naked eye, even with the short signatures put on Exhibit A3. From the above, it is evident that the applicant bank has miserably failed to prove its case that the defendant number 2 has executed and signed the guarantee deed for the term loan for 3 hypothecated vehicles availed by the defendant number 1, and also that the defendant number 2 has extended the mortgage for this loan and executed and signed Exhibit A12, A14, and A17. Hence, the defendant number 2 cannot be held liable for the term loan neither as a guarantor nor as a mortgager for the term loan availed for 3 Tata Motor buses. So, my lord, this is the finding, and in the operative part, if your lordship comes, my lord, yes, page 334, my lord.
Yes.
My lord, this should be the 4th paragraph, my lord. Since the liability, yes, since the liability of the defendant number 2 is only for housing loan account, hence the applicant bank is directed to file revised statement of account showing separate liability of the defendant number 2. In the result, I pass the following order, issue RC so and so. Now, and the same direction is repeated, my lord, at page 335. The liability of the defendant number 2 is restricted only for housing loan account. Hence, the applicant bank is directed to file revised statement of account showing separate liability of defendant number 2. So, the liability of the mother, my lords, the mother of the informant was restricted to only the first loan of 9 lakhs. And the other loans, her liability was not. Against Prasanto, it continued. Against the other guarantors, it continued, but not for her. That is the finding. The lordships have seen that all the documents, etc., was executed during which period? The entire period was between 2003 to 2006, when these present defendants had nothing, the petitioners had nothing to do. Only for the purpose of assisting your lordship, if I may hand over one small detail, my lords, executing as to when these people were in the scene. I've already, my lord, narrated these things in my petition itself. I have narrated, my lords, in para 2 of my criminal petition. Yes. Now, my lord, petitioner number 1, Sunil Kumar Sinha. My lords, he was the authorized officer of the recovery department at the bank's circle office in Gauhati, my lords.
Okay.
And the time period when he was there, my lord, 24/5/2010 to 11/5/2013. And he has, my lord, retired way back on 30th of November 2014. Now, my lord, he is settled in London, my lord. Anyway, so the period is very important because the loan taken 2003-2006, judgment of the DRT comes in 2017. And the only allegation, as I pointed out against this petitioner, is that he wrote to the deputy commissioner that, look here, we have to take physical possession of this property. That letter, my lords, was sent in the year 2011. When, as a part of his duty, under the Surface Act, he is an authorized officer, he has done his duty, that look here. He need not, my lord, go and examine each and every loan document and see, and because he is not, that is not his, if he starts doing all this, he will have to, my lord, leave the bank. Now, petitioner number 2, Prashant Kumar Dwivedi, my lords, he was the senior manager of the Dibrugarh branch between the period, my lord, 13 August 2013 to 17th of July 2014. And after, on 17 July 2014, my lords, he was transferred from the said bank. What is the accusation against him? That he has filed the affidavit in the OA case. Signed the affidavit in the OA case. That is the only allegation against him. Now, if we come to petitioner number 3, my lord, Deepak Kumar Sengupta, he, my lords, was the successor of Mr. Sinha, petitioner number 1, in the post of authorized officer recovery department at Gauhati for the period, my lords, 11th of June 2013 to 19th of February 2016.
Okay.
And, my lord, he also has retired way back on 1st of September. I have indicated, my lord, the retirement dates, transfer dates, just 2 minutes. 1st of September 2016. And during his time as the authorized officer, my lord, he issued the sale certificate which your lordships have seen. The sale certificate dated, my lord, 18 June 2015. Now, petitioner number 4, my lord, Debango Bhushan Hazorika. He was the senior manager in that branch, my lord, Dibrugarh branch, 22nd of June 2015 to 3rd of July 2017, my lord. And on 4th of July 2017, my lords, he was transferred out of that branch. And during his period in that branch, the allegation against him is that he wrote to the circle office that the auction purchaser's name should be mutated. because the property was sold in the auction. And the, my lords, his name has to come in the mutation record in a Jamabandi. So he has written to the circle officer that please include, we have sold this property, please include his name. That is the singular accusation against petitioner number 4. Now petitioner number 5, my lord, PT Namgyal. Mr. Namgyal was the chief manager of the Dibrugarh branch, my lord, that same branch, 6/11/2013 to 29/5/2015. And on 29/5/2015, my lords, he was transferred out. Now he is also retired. And the accusation, as your lordship have seen against him, is that he signed, my lord, the evidence on affidavit and filed various cases or defended various cases on behalf of the, my lord, bank. Now, your lordships would permit, look, the charge, the cognizance has been taken under 417. You know, lordship will kindly see, the lordship knows, my lord, that
Yes, yes.
417 presupposes that there are the elements of 415.
IPC only, yes. You want to read 417?
My lord, 417 is nothing but which is a
Punishment,
it's a punishment is for
section.
cheating simpliciter. We call it cheating simpliciter, my lord, because unlike 420,
Nothing,
there
yeah.
is no delivery of property. But my lord, if I may just read, lordships, I have heard it, let me just
Yes.
rehearse, my lord. Whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, and property, is said to cheat. A dishonest concealment of facts is a deception within the meaning of this section. Now, my lord, I say, my lord, against the petitioners, there is not a single allegation or nothing to show that there was any deception or there was any, my lord, inducement on their part. Who have they deceived? Who have they induced? Is the allegation that they have induced Prasanto Kakoti? Cannot be, my lord. Loans were sanctioned in 2003, 4, 5, 6. None of these people. And my lord, the paragraph 2 of my petition has not been denied by them, that these people were in office at that point of time, that they were responsible for the loans. No. In fact, as I have shown, the complaint itself says all the documents were prepared during that time when the accused number 1, my lord, Vipul Khatoniar, was in, with whom he was in league. Now, my lord, since 415 is not satisfied, so there, my lord, there is no question of my lords, this 417 coming into play. Now, my lords, if we go by the accusation of filing false affidavit, lordships will kindly have, my lord, chapter 11, my lords, of the IPC, because assuming, my lord, that I have filed a false affidavit, what is the punishment? It is under chapter 11 of the IPC, my lord. 193, lordships are aware, my lord, punishment for false evidence. If I have filed a false affidavit, false evidence, forged, because, my lord, the important thing is that cognizance has not been taken under 463, 467, 468. There is no allegation that there is no cognizance taken on those sections. So I do not have to go on 463, etc., etc. Now, as your lordship knows, that if I have given false evidence and offences, etc., the sections will be, my lord, 193, my lord, 197, perhaps, 199, 191, 192, all these, my lord, will come into play. Now, as your lordships are well aware, my lord, if your lordship will kindly have the CRPC,
Yes.
the lordships have got the point, I think.
344 or 340.
195. Where is the complaint by the court? They could have filed an application that, look, these people have filed a false, or 1 or 2 of them have filed a false affidavit. They should have pursued that remedy. If we assume that these, on the face of it, it makes out that one of the petitioners filed a false affidavit, though that is not the case, but still I am going on to argue that point. That 193 is involved, 199 is involved. Then, my lord, those would be barred because the court has to make a complaint. Now, whether, my lord, an argument may come, perhaps, that court could not have because it is not a court. It is a court. Your lordship will RDB Act on recovery of debts act. Recovery of debts. Or I can hand over, my lord, for a minute. Or I will just read out, perhaps. Well, Section 22 of the Recovery of Debts and Bankruptcy Act. What you will kindly have,
Yes.
my lords, subsection 2 of Section 22, my lords.
Yes.
Any proceeding before the tribunal or the appellate tribunal shall be deemed to be a judicial proceeding within the meaning of sections 193 and 228, and for the purposes of section 196 of the IPC, and the tribunal or the appellate tribunal shall be deemed to be a civil court for all the purposes of section 195 and chapter 26 of the Code of Criminal Procedure. So, my lord, the tribunal is very well competent, my lord, to make the complaint under 195. That, look, this is a false, an affidavit has been given falsely, or a false document has been filed. Whether they filed any application before that? No. Can they sustain a complaint, my lords, under 417 IPC, under the guise that, look, by filing a false affidavit in the
No, but
court,
the case was already disposed of, no?
lordship?
The case was already disposed of. At that time, they won't be able to file.
No, at that time they will be, because my lord, otherwise
Or they apprise the
195.
tribunal also. Tribunal then.
Tribunal,
they-
because yes, the tribunal has
It
to
was
do
the
it.
duty of the tribunal.
It was the duty of the tribunal. But did they approve the tribunal, my lord, once, even after the judgment, was any application filed? No. I'm not saying that they should have done it. What I'm saying is that, my lord, on the allegations, let us assume the allegations are correct. Somebody has filed a false affidavit. What is your remedy? 417 is not the remedy. 417 cannot come into play because there is no inducement, deception, nothing. Now, the lordship will. I would like to hand over a few judgments, my lord.
Continue ক'ব লাগিব। ক'ব লাগিব।
Well, I can give a short note later on that will, I think, with a proper list.
Okay.
That will be better, but I would just like to let. Citation কেইবাটাও আছে। মই read out কৰিছো। কৈ দিম। Well, the first one, lordship will kindly have the judgment in the case of M.N. Ojha, my lords. It's 2009, 9 SCC 682. Because I have taken the liberty of picking some of the relevant paras to save your lordship's time. Lordship will kindly have para 12 onwards now.
Okay.
Yes. Shri so-and-so learned counsel for the appellant submitted that the High Court failed to appreciate that the complaint has been lodged with a completely malicious intent to simply harass the appellants who were only discharging their duties as public servants, which is nothing but an abuse of the process of law. The averments made in the complaint are totally indefinite in their nature, and none of the ingredients of the offences alleged to have been committed are made out against the appellants. Shri so-and-so also contended that the summoning order has been passed by the learned SDJM without application of mind and contrary to the law laid down by this court in more than one judgment. They submitted that the complaint was filed as a counterblast to the FIR already lodged by the bank on so-and-so for cheating and misappropriation of hypothecated goods against the borrower and as well as the guarantors. Now, para 16, well, it is evident from the record that the bank had lodged FIR with the police on 22/2003 for cheating and misappropriation of hypothecated goods against the borrower as well as the guarantors. The police initiated action against the complainant and others based on the said FIR lodged by the first appellant on behalf of the bank. This fact is specifically admitted in the legal notice issued for and on behalf of the guarantors, including the complainant. We have no doubt whatsoever in our mind the complaint dated 3/12/2003 filed by the complaint against the appellants after almost about 10 months of the FIR lodged by the first appellant on behalf of the bank is nothing but a clear abuse of the judicial process to harass the appellants. The complainant himself admitted in his complaint that the account in question was gradually becoming irregular, and the manager ought to have taken steps for sale of the hypothecated goods and appropriated the sale proceeds towards recovery of the loan amounts. It is the case of the complainant in his complaint that the first appellant should have appropriated the hypothecated goods first, and only thereafter steps could have been taken for recovery of the balance amount, if any, from the guarantors. It was alleged that the branch manager, in conspiracy with the brother of the borrower, here also brother, who is none other than an employee of the bank, allowed the operation of the account till the things became bad to worse. According to the complainant, the branch manager conspired with the borrower and committed criminal breach of trust. Repeated assertions have been made in the complaint that all the accused persons in conspiracy with each other have diverted huge amount of bank money in a fraudulent manner for their own benefit. Surprisingly enough, neither the borrower nor his brother, with whom the bank officers are alleged to have colluded, is arraigned as an accused. Similarly, the complainant in his complaint freely used choicest expressions such as fraud, collusion, conspiracy, and cheating, etc., but did not make any concrete allegations against the appellant suggesting commission of any offense. That a plain reading of the complaint and taking the allegations and averments made therein to be true on their face value do not reveal the commission of any offense whatsoever by the appellants, who are only taking steps to realize the amount due to the bank from the borrower and in the process encash the FDRs offered by the guarantors as security for the discharge of the loan. What is the crime they have committed, even if they did not proceed against the hypothecated properties before realizing the FDRs offered by the guarantors? Where is the misappropriation of money? Whom did they cheat? In our considered view, criminal law has been set in motion by the complainant to harass the bank officers needlessly and to wreak personal vengeance in order to bring them under pressure not to further prosecute the proceedings already initiated by the appellants against the complainant on behalf of the bank. In our considered opinion, the learned SDJM set the criminal law in motion against the appellants without even examining the allegations and averments made in the complaint filed by the respondent complainant. The learned SDJM took cognizance of the case without considering the allegations on merits. Had the learned SDJM produced the complaint properly, he would have realized that the complainant himself had made a mention about the lodging of the FIR for criminal breach of trust and other offences against the respondent complainant and others. Had he looked into the complaint properly, he would have certainly asked the complainant to furnish a copy of the said FIR. A copy of the legal notice issued on behalf of the respondent complainant to the appellants was filed along with the complaint, and a mention is made about it in the order passed by the learned SDJM. Had the learned SDJM produced the said legal notice, he would have realized that the complainant himself admitted about his execution of agreement of guarantee and other documents unconditionally agreeing to discharge the loan amount in case of failure of the principal borrower to pay the said amount to the bank. Had the learned SDJM applied his mind to the facts and circumstances and sequence of events, and as well as documents filed by the complainant himself along with the complaint, surely he would have dismissed the complaint. He would have realized that the complaint was only a counterblast to the FIR lodged by the bank against the complainant and others with regard to the same transaction. Now, Lord, Pepsi Foods is quoted. Lordships are aware. I will not read. The para 27. The case on hand is a classic illustration of non-application of mind by the learned magistrate. The learned magistrate did not scrutinize even the contents of the complaint. Leave aside the material documents available on record. The learned magistrate truly was a silent spectator at the time of recording of preliminary evidence before summoning the appellants. The High Court committed a manifest error in disposing of the petition filed by the appellants under Section 482 of the Code without even adverting to the basic facts which were played before it for its consideration. It is true that the court, in the exercise of its jurisdiction under Section 482 of the CRPC, cannot go into the truth or otherwise of the allegations and appreciate the evidence, if any, available on record. Normally, the High Court would not intervene in the criminal proceedings at the preliminary stage when the investigation and inquiry is pending. Interference by the High Court, this is regarding 482. We are not so much concerned. My Lordship will kindly have para 33. This is one case where the averments and allegations made in the complaint do not disclose the commission of any offense by the appellants or any one of them. They were merely discharging their duties to realize and recover the amounts due to the bank from the borrower as well as the guarantors. The complaint obviously has been filed as a counterblast to the proceedings already initiated by the bank, including the first information report lodged by the first appellant against the complainant and the borrower for the offences of cheating and misappropriation. Sequence of events undoubtedly suggests that the criminal proceedings have been maliciously instituted with an ulterior motive of wreaking vengeance on the appellants and with a view to spite them due to personal grudge. It was clearly intended to prevent the public servants from discharging their duties. The criminal law has been set in motion by the learned SDJM on mere asking to do so by the complainant. The High Court almost abdicated its duty in refusing to exercise its jurisdiction under Section 482 of the CRPC, though the case on hand required its interference in order to prevent abuse of the process by a court subordinate to it. A clear case is made out requiring our interference to secure the ends of justice. For all the aforesaid reasons, the impugned order of the High Court is set aside. Criminal proceedings are accordingly quashed. My Lord, that was also a case, my Lord, where the bank officers were simply doing their statutory duty, my Lords, which is required by them. And in that case also, my Lord, the brother of the borrower was involved. If your Lordship will have the other judgment of the Supreme Court, my Lord, this is A.M. Mohan versus State, my Lord.
Okay.
2024 INSC 233. This is regarding, my Lord, the ingredients of 415. What should we kindly have, my lords? There are 11, my lords. Internal page is 732.
Okay. Yes.
This court in the case of Professor So-and-so versus Sudha Sitaram and others has culled out the ingredients to constitute the offense under sections 415 and 420 of the IPC as under. Section 415 is quoted, my lord. The ingredients to constitute an offense of cheating are as follows. There should be fraudulent or dishonest inducement of a person by deceiving him. The person so induced should be intentionally induced to deliver any property to any person or to consent that any person shall retain any property, or the person so induced should be intentionally induced to do or omit to do anything which he would not do or omit if he were not so deceived. And in cases covered by 16.12 above, the act or omission should be one which is likely to cause damage to, or harm to the body induced to the person induced in body, mind, reputation, or property. A fraudulent or dishonest inducement is an essential ingredient of the offense. The person who dishonestly induces another person to deliver any property is liable for the offense of cheating. My lord, deception, inducement. My lordship, running out of time.
We cannot continue in the afternoon.
I think there is another
We
matter.
have fixed a
Step
matter.
two.
As you lordship, on any day,
But you
Any
can have
day,
it
yes.
Thursday perhaps. It's okay.
Thursday kiba asa ni at 2. We have many hearings fixed on Thursday. Huh? Next week.
Lordship will give it as part early.
Yes, I'll leave it as part
Or
of
part of-
the
part of
hearing
hearing.
the afternoon.
you lordship, give it for father here.
You can complete your
Judgments.
yes, judgments.
Not at 2 or
No,
I'll take some more time.
some more time.
Lordship,
Okay.
I'll continue on the next day.
Okay. Then I'll keep it with me only.
20th.
Lordship will give it.
All right.
Because I'll try to give a compilation that is
Oh, very good.
Okay.
with a proper page.
Or 20, huh? 28th. Well, is 28th suitable to this court?
Yes. Huh? Yes.
28th.
28?
28 might be Eid hoga.
Huh?
I think it has been declared as
Subject-
Eid.
Already declared?
27 has been.
So it's already
holiday.
In maybe 27, maybe
That is the
28.
difficulty.
That happened in this Eid. That moon.
Yes, yes.
I don't think so. This
No,
yeah,
no.
he will know better. It will be okay.
So
I'm not an expert.
So 27th is shown as holiday here.
Yeah, 26th holiday, but it will be 20. So any other day.
Huh?
26.
26th, no, like.
25th, yes, because
But-
we can take up on 25th pioneer.
But
26th,
26th, I may have some difficulty.
25th?
I'm there, my lord. This is all
25th at 2 then.
at 2.
25th on.
At 2.
Oh, at- Much obliged. 25th.
Council
25th.
Ganguly
At 2.
for the petitioner. Most of the respondent is represented by learned counsel Mr. Guswami, B.D. Goswami, then Mr. P.C. Goswami, and therefore respondents are represented. Mr. J. M. Gogol. Anybody else? No?
Well, my.
List this matter as part of matter at 2.
At 2. On 25th.
2 on 25th May.
Much obliged.
I thought it would be over within this first half, but
There's too many
never-
facts, my lord, and it's very longest proceeding, man, from starting from 2008 and all these things.
This story started in 2012. It's now been 14 years.
2003.
No,
Yes.
2003.
since the time the
Okay.
dispute arose. Dispute
yes,
arose in
yes.
2012.
From the dispute. Okay.
May it please your lordship. My lord. This is a revision, my lord. Petitioner, he was convicted under section 354 for 2 years. And
Convicted under section 354 for 2 years.
2 years. And then there is a appeal, my lord. An appeal also dismissed, my lord, without giving any reason. And my lord, now, my lord, your lordship kindly see, first of all, my lord, in this case, my lord, very interestingly, probably how this prosecution has, my lord, established the case, I do not know. MO and IO was not examined, and I am seriously prejudiced because of these two ground, my lord. I'll come to that, my lord, later on. That appellant, the petitioner at present, he's a 70-year-old man. He was a doctor by profession. At present, he's 70 years. At that time, my lord, he was 58 years. Now, last 12 years, my lord, he's pursuing this case, my lord. So he is a practicing advocate in my lord, practicing doctor in my lord, Morigao town. And now I'll start from the FIR, my lord. Your lordship kindly see, since there is a division, there is no paper book. Your lordship has to, my lord, go to the record, my lord.
I'll go to the record, yes.
My lord. Your lordship kindly see that FIR, my lord.
Yes, you can read the FIR if
My
you
lord.
want to, because FIR is checking the record. PP is not ready, so he's checking the record.
I'm going to the
Yeah.
PCR.
Please, you
My
can
lord.
continue.
I will just-
We can read the FIR.
My lord. My lord, FIR, yes, my lord. এজাহাৰকাৰী বিনীত নিবেদন এই যে আজি প্ৰায় এক মান বজাত এজাহাৰকাৰী ভনী, because FIR was lodged by my lord, brother of the victim, my lord. ভনী শ্ৰী তিলোত্তমা দেৱী বয়স 17 বছৰ, মাহেকীয়া নিয়মীয়া হৈ থকা অনিয়মীয়া হৈ থকা
The made a party, but I think that service, as per his record, I think that his party. Already we have taken steps, man, no?
We have received the records, but
Amicus full, man.
But the only we have to confirm whether service
Can-
report is
can-
complete.
appoint-
let him confirm next date. Okay?
My lord.
Then a short date, can be.
Yes, short date.
Good it money.
Land Council, Mr.
No moving, no? I has it.
I,
Hazarika.
A Hazard is present for the petitioner, puts up line SLPP, Mr. Ajit is present for the respondent state, and has submitted that he will obtain instructions. Notice has been served to respondent. Number 2, is the matter on?
Number 6 May.
POCSO matter, Lords. Under section 4 of the POCSO Act, Lords.
You want to,
PCR may be called for, Lords.
will call for the,
Lords.
but.
Our service report is awaited, my lord. I'll
But
upon
you
instruction.
can apply for bail before the trial court also.
Lordship,
It will
normally,
be your
it's under
advantage.
under section 6, Lordship.
Trial court will grant you bail, trial court can grant bail under section 6. It's up to you.
Lordship, kindly come, follow that case this year.
Service report and respond number 2 is awaited. We'll await for the service report or you.
No, I'll take instruction, my lord.
Meanwhile, as Hasid has been submitted, the learned counsel for the petitioner is willing to press this bail petition in this court, call for the, and has prayed to call for the scan copies of the trial court records, full stop, call for the trial, scan copies of the trial court records along with the scan copies of the CD, list the matter and date.
Obliged, Lordship.
No. May please, your lordship. My lord, this is the case, my lord, kindly see the Ejahat at page 14, my lord. The vernacular part of the Ejahat, my lord.
Okay.
Page 14.
First 14 minutes.
এজাহাৰ মেলো সম্মানপূৰ্বক বিনীত নিবেদন এই যে মই আছলিমা নাৰ্ছিন ইজ দি ইনফৰমেণ্ট মেলত উপৰোক্ত পদকীয়াজনৰ লগত মই নাবালিকা থকাৰ সময়ত তেওঁৰ লগত প্ৰায় 16 মাহ আগৰ পৰাই প্ৰেমত
What is the record of the ADM has come?
Was also there.
ADM's record has come.
I have not gone through that.
ADM's record was there. Lordship.
145 was.
Yes, there, Lordship. 2 other files are there. Whether that was the only file or not, I do not know. On the cover, it was stated that the this
ADM ADM, have you gone, have you preferred any appeal against the ADM's order?
Yes, yes, yes.
Okay.
Revision.
Revision against the ADM's order?
Yes, yes. That order.
But PRC case is not required here. এইটো ক'ৰ বেলেগ ক'ৰবাৰ আহিছে দেই
বেলেগ ফালে I have some.
PRC কেছ হয় এইটো
অন্য দুটা ফাইল দিছে।
এইটো 120B 326 302 IPC
No, no, these are not.
আঁতৰাই দিছো ক'ৰ বেলেগ এটা ৰেকৰ্ড ভৰাই দিছে তাৰপিছত এইটো হ'ব ADM-ৰ ৰেকৰ্ড
It should be 190M/2009.
190M 2009, yes. We have this record.
And revision is criminal revision 32.
190M 2009. এইটো এটা আৰু এটা আছে সেশনস কেস এইটো এটা আছে 302 হয় এইটো Actually, maybe we have called for the order of revision. Maybe then they have sent something else. এইটো case number কিমান দিছে এইটো
SC?
সেইকাৰণে দিছে 190M খুজিছিলো তো সেইকাৰণে 1SC19 দি দিলে ইয়াতে Criminal Revision 32 of 2025 দিছে নেকি কেনেবাকে Criminal Revision Petition 30 of 2025 দিছে নেকি নাই অকল ADM-ৰ ৰেকৰ্ডটো আছে We don't have the order of the district judge.
The district judge order we have annexed, but whether records should be necessary because it was.
Do you want the record?
No, no.
Not required, okay.
In this case, what happened, Your Lordship? This petitioner has purchased all total 10 katas of land from the predecessor of the respondent number 2. One was by way of a sale deed number 280 dated 7/3/2003. 6 katas of land were purchased, and another was by way of a sale deed of 2007. Another 4 katas in the name of his wife. So altogether 10 katas of land, it is a compact land, were purchased. And then, Your Lordship, the petitioner has constructed the boundary wall and all these things. At that time, in the year 2009, Your Lordship, the respondent has filed a proceeding under section 145, 146 CRPC, claiming that he is the owner of the land. And that petition, Lordship, I have also annexed at annexure 1, page number 17, typed copy. Now, he sought for a proceeding under section 145 and also sought for an injunction under section 146(1), status this attachment. Accordingly, an attachment order was also passed, Your Lordship. Subsequently, Your Lordship, on getting the notice, the petitioner herein, he has filed his response, Your Lordship. And after that, Your Lordship, the responses also I have annexed. Status quo order was carrying on. At that time, the ADM called for a police report on the issue. That report, Lordship, will find at page number 25.
Okay.
Now, in that report, it has been.
Page 25, yes.
Page 25. The report was called. Lordship will kindly note that the proceeding started in the year 2009 only. In 2011, this report was called for. So, it was given by the then circle officer, Silchar Revenue Circle, to the learned ADM. May I read for a moment, Your Lord?
Yes, yes.
In continuation of this office letter number so and so, I have the honor to inform you that self, along with the alert staff, visited physically to the spot at Moja so and so. The land in dispute falls under Patta number so and so. I visited the dispute land and found a kacha dwelling house on the said land, which is constructed by second party Khalikuddin Chaudhary, the petitioner herein. The said land is bound by bricks boundary wall. The second party purchased the said land through registered deed wide number so and so, and further moved the wife of second party Hamida Khanam Chaudhary also purchased the land in the said patta, and the whole land total measuring 10 katas within the said boundary. The second party has been possessing the said land, having dwelling kacha house, and the possession of the first party has
So
not
petitioner and his wife together they purchased 10 katas.
total 10 katas of land, which now he's saying that it is his ancestor property, he should get it. So he said that he is the owner of the property, so he has done the 140 proceeding, saying that we may take over the possession of the land. Now, the report says that we have purchased the land on the basis of sale deeds, the possession, and there is no chance of any. The second party has been possessing the said, having dwelling kacha house, and the possession of the first party has no local evidence as referred to by the first parties. As such, there is no apprehension to breach of public peace of the locality in respect of the proceeding of the land. So a report was basically in our favor, Your Lordship. Thereafter, Lordship, he has filed a petition before the ADM itself at page number 26. I have given. He said that he is willing to give back the money. Said the amount which you have purchased the land, he is willing to give back the money, and he should be given the possession, Your Lordship. This is an application. It is a typed copy. The original also I have annexed, Your Lordship. Now, at page 28, Lordship will see. Last paragraph, what he's saying, Your Lordship, in this petition. Now, he has accepted that I have purchased it by you have a purchase sale deed. In view of above, I am to state that the office second party may be asked to take return the transaction money as per registered deed along with registration costs, etc. as admissible.
From
And
whom did he purchase the land?
from the it was a ancestor property, Your Lordship, from his uncles, his brothers, those who had got the possession, those who had inherited the land, Your Lordship. He has no right over this land, Your Lordship.
Why? His uncles and brothers, why he won't have
No,
over this
they-
land?
That has been, they have separated the patta and doing all these things, Your Lordship. After
Patta has to be separated, yes.
Yes. So that sale deed, when sale deed was executed, Your Lordship, everything was gone into by the revenue office, Your Lordship. Suddenly, if I say that it is mine and it cannot be so, Your Lordship. And ultimately, this 148, 146 proceedings cannot determine as to who is the owner of the land.
Yeah.
That is that.
Now, what he's saying that in view of the above, I am to state that the office second party may be asked to return the transaction money as per registered deed along with registration, etc., and for which I am ready to pay the requisite money and amount. He made an application before this, Your Lordship. Now, Your Lordship, the proceeding was carrying on, Your Lordship. In the meantime, he has filed a title suit also before the learned competent court, civil court, Your Lordship. In the title suit, we got notice, Your Lordship. We appeared and we have filed our response, written statement. Thereafter, Your Lordship, he did not adduce any evidence in spite of giving several chances. And thereafter, that title suit was closed. I have annexed the order at page 32. Title suit number 189 of 2014. During the pendency of this 145, 146 proceeding, he has instituted a title suit, Your Lordship. We have filed our response in the title suit. Written statement was filed. Thereafter, he was given several opportunity to produce evidence. He did not adduce any evidence, and ultimately that title suit was dismissed by way of an order dated 9/9/2016.
189, 2014.
189 of 2014.
99, 2000.
9/9/2016 order is at page 32.
Yes, was dismissed.
Dismissed, Your Lordship. If Lordship peruse the order for a moment.
Page?
32. Both sides represented. Plaintiff side filed the verified petition number so and so, praying for not filing evidence of the plaintiff side showing cause mentioned in the petition. Seen petition heard. Perusal of the case record shows that since 29/4/2016, plaintiff side has been repeatedly taking steps for filing evidence of the plaintiff side, but till date no evidence has been filed. Hence, case is dismissed due to non-prosecution. Several dates have been given, and every time they come and say that we will file evidence. Ultimately, the suit was dismissed for non-prosecution, and against this, Your Lordship, there is no appeal. They have not preferred any appeal, or they have not filed any petition that to set aside the order and to restore the suit again. So that has attained a finality that the title suit was dismissed.
Okay.
Now, Your Lordship, in the meantime, the land has been mutated in our favor at page 34, Your Lordship. Mutation was done by the circle officer, SHN settlement officer, and that is also I have annexed at page number 34 during the pendency of all these proceedings, Your Lordship. Now, in the proceeding, Your Lordship, they have adduced in the proceeding before the ADM, Your Lordship, they have adduced three evidences: PW1, PW2, PW3. we have cross-examined them. And we have adduced three evidences. DW1, DW2, DW3. In spite of repeated chances, your lordship, they did not cross-examine. Several dates were given. Ultimately, your lordship,
So you are the DW in that proceeding.
no, sorry, we are the PW, we are the DW.
In the proceeding.
He is the DW1, DW2, DW3, your lordship. Several occasions they have taken time, but they did not cross-examine any of the defense witnesses, your lordship. That took several dates, and ultimately on 16/8/2023, 16/8/2020, Larder ADM closed the cross-examination of DWs. That no further question will be given. He has closed it because several dates were given, but they did not cross-examine. So that order was also not put to challenge. Against that order also, they did not prefer any appeal.
Okay.
Now, your lordship, the learned ADM was about to conclude the case because the case is pending since 2009, your lordship. So what happened when the learned court was about to go for final hearing, your lordship, they again filed a petition. The respondent number 2 has filed a petition saying that some new persons are required to be implicated in the case. That petition was dismissed by the learned ADM on the ground that those persons who want to be implicated, nobody have signed. There was no sign on the petition, and the persons who are required to be admitted, they have also not come, your lordship, before the court. So the impleadment petition, one impleadment petition was dismissed. Now that was also not put to any challenge before any higher forum.
Okay.
Thereafter, they have another impleadment petition was filed by one Minara Begum on behalf of the respondent number 2. That petition was also dismissed on the ground that Minara Begum has no right title over the suit patta. From the record, it is seen that there is no person called Minara Begum, and therefore she is not required to be impleaded. That impleadment petition was also dismissed.
Second impleadment petition.
Second impleadment petition filed by one Minara Begum on behalf of the respondent number 2. Now, they were trying only to prolong the case as long as possible, your lordship. Ultimately, the learned court below, ADM, fixed a date for hearing, your lordship, that on 9/11/2023, he fixed a date that I'll pass the judgment on that particular day. On that day, your lordship, they have filed an application before the under section 411 CRPC saying
9/11/2023
was fixed for final delivery of the order in this particular case, your lordship.
Then what? One petition was filed?
Respondent number 2 filed a petition under section 411 CRPC for withdrawal of the case to any other ADM. He said that he had some problem with this ADM, and therefore the matter may be transferred to any other ADM.
Okay.
Now, by way of an order, your lordship, the case was transferred to another ADM subsequently, your lordship. Now that after coming, your lordship, the new ADM called for a fresh police report, which I have annexed at Annexure 6, page 35, dated 9/1/2025. And in the fresh police report also, your lordship,
Page number?
35.
Okay. All right.
In that police report also, the police reported that there is no apprehension of any breach of peace. He has verified the sale deeds, and he said that we have purchased the land. Our name have also been mutated, and there is no apprehension of any breach of public peace or something like this. Ultimately, your lordship, by way of an order dated 28/3/2025, the case was finally decided by the learned ADM, your lordship.
Which page?
Page 37.
Okay.
Now that order is very important because that was put to challenge by them in the revision, your lordship. I'll just read the. After about 2009-19, after about 16 years, your lordship, ultimately a proceeding under section 145 was disposed of by way of this order. 16 years. The lordship will kindly see the order. Paragraph number 3. The first party, that is they, your lordship, adduce evidence which have no basis, having no any documents.
Okay. Yes.
The first party adduce evidences which have no basis, having no any documents. The second party was examined, but the first party did not cross-examine the second party as DW1 and other witnesses of second party. The second party submitted evidences in chief as DW2 and DW3 respectively, but the first party failed to cross-examine the DW2 and DW3. Although the first party got several dates to cross-examine the same. Later on, the evidence of PWs were closed as per instruction of this court. At that stage, the first party submitted a petition for impleadment after about 13-14 years of filing of the case. The impleadment petition was not signed by any of the parties interested to get impleaded. As such, the said petition for impleadment was disposed of. And again, recently, the first party filed another petition for impleadment, which was signed by one Srimati Minara Begum, but the said Minara Begum has no land in this case as per the record. Moreover, the said petition contains no schedule of land and not supported with affidavit, and as such, the said second party's impleadment petition also cannot be entertained in the meantime. After proper process, the date was fixed on 9/11/2023 for order, but the first party filed a petition for transfer of the case to the court of any other additional district magistrate, and the said petition was allowed, and the case is hand transferred to this court for disposal. Since then, the instant case is pending in this court for disposal, and as per order dated 28/11/2023, a police report is received, which is in the record, and the police does not support the case of the first party. So after perusal of the record, it appears that the first party has not submitted any petition to vacate the order dated 9/11/2023, and hence this case exists in the same stage, that is order. Next page, Your Lordship. The second party submitted written argument which is in the case record, but the first party did not submit any written statement, and the first party does not approach this court for vacating the earlier order dated 9/11/2023 for order. So it is proper to pass final order in this case. The first party stated that the land is in his possession as title holder, but as per cross-examination, the first party never submitted any document as to prove his case. The first party also adduced evidence of other witnesses, but the prosecution witness do not or does not corroborate the evidence of first party as PW1. The second party deposed as DW1, and he told that he had purchased the disputed land along with his wife, and he further stated that the land was in his possession being title holder, and he states again that there was no any possibility of breach of public peace at the locality, and in this way he proved his case by exhibiting his documents. Need to say that the first party has failed to cross-examine the second party and his witnesses. The DW2 and DW3 states that the second party has been possessing the land got by right of purchase, and they also state that there is no chance to breach of public peace in the locality. Thus, it appears that the second party has proved the case by adducing evidence, witnesses, and exhibiting documents. Considering the corroborated statements of DW1, 2, and 3, it can safely be held that the second party is in exclusive possession of the disputed lands with purchase, having their valid right, title, and interest over the disputed land. From the above, and on perusal of available materials on record, I am satisfied to believe that the disputed land is possessed by second party prior to filing of the instant case, and in my opinion, the first party failed to prove the case, and hence I declare the possession of the disputed land in favor of the second party until otherwise decided by any competent court of law. Accordingly, the attachment order dated so and so is also hereby vacated. Now, this was a very redundant order, Your Lordship. Against it, they filed a revision before the learned Court of Session Judge, Your Lordship. And on revision, Your Lordship, the learned court below, first appellate court below, has once again reverted the matter back to the IDM, saying that he should again decide, Your Lordship. A case which started in 2009, ultimately decided in 2025, was reverted back, Your Lordship. I will take Your Lordship to the relevant paragraphs. The impugned judgment starts from page number 48, Your Lordship. 8/7/2025 is the order, Your Lordship. The relevant Lordship can come to page number 55.
Page 55.
Lordship,
Okay,
paragraph number 7.
okay.
On perusal of the impugned order dated 28/3/2025 and also the connected case record, it is found that the learned court below observed that the second party has proved the case by adducing witnesses and exhibiting documents, and hold that the second party is in exclusive possession of the disputed land since purchase having their valid right, title, interest over the dispute and finally declared possession of the suit land in favor of the second party OP. It appears from the case record that the second party adduced evidence in chief of 3 witnesses, that is DW1, DW2 and DW3. Although several dates were given to the first party, but the first party failed to cross-examine the witnesses of the second party. Thereafter, on 16/8/2023, the second party has filed a petition with a prayer to implead certain other co-sharers of the disputed land in the case, but the learned court below rejected the said petition by order dated so and so and finally declared possession in favor of the second party OP. Now, both these orders were of 2023, Your Lordship. One of closing of the witnesses and another of rejection of impleadment petition. Both are of 2023. After hearing the learned counsel for both sides and after perusal of the case record, it appears that the second party presented evidence in chief of 3 numbers of witnesses, DW1, DW2, DW3, but they were not cross-examined by the other side. I agree with the submission that several opportunities was accorded to the first party, but the first party failed to cross-examine them. Another contention made in this case is that the first party repositionist side preferred a petition before the learned court below on 16/8/2023 to implead certain co-sharers of the disputed land for just and right decision of the case, but the learned court below rejected the said petition without reflecting any reasons for rejection of the said petition, which is illegal in my opinion. Now he has taken up an order of rejection of plaint, which has not been challenged here also, 16/8/2023. Now he is saying that that order according to him is not correct. That is not also under challenge, Your Lordship. At that time, they might have come that we wanted to implead, but that order has been, our petition has been dismissed. They did not come for that. Now they have come with the main order, Your Lordship. But the learned court below was of the view that the order of rejecting the impleadment petition was bad, Your Lordship. And that was rejected on 16/8/2023, which is also not under challenge. So what another contention means first party review side preferred a petition with the learned 16/2023 to implead certain co-sharers of the disputed land for just and right decision, but the learned court below rejected the said petition without reflecting any reasons for rejection of the said petition, which is illegal in my opinion. On perusal of the impugned order, it appears that though the second party OP claimed to have purchased 10 cutters of land with separate boundary, but the learned court below declared possession of a total 16 cutters of land involving the land of the first party revisionist with separate boundary. Then, Lordship, he has referred to one judgment of the Honorable Supreme Court as to how 145, 146 proceedings are to be done. And then at paragraph 11, Your Lordship, considering the entire facts and circumstances, I am of the considered view that the case is remanded back to the learned court below to facilitate the first party to cross-examine the DWs. He said that again it should go back and they should be given a chance to cross-examine the DWs within 3 months from today. It is further directed the petition that was submitted by the first party on 16/8/2023 for impleadment that shall also be considered after hearing both sides. Further, the learned court is directed to peruse the prayer and schedule of the land to make it order legally sustainable. Now, Your Lordship, this impleadment petition was dismissed long back in 16/8/2023. They have not come in appeal. The cross-examination, after giving several dates, Your Lordship, the cross-examination was closed on 16/8/2023. They have not come in appeal. Now, they have challenged the impugned order, Your Lordship. Now, the learned appellate court below is of the view that the matter should again be remanded back so that the defense witness can once again be examined, Your Lordship, cross-examined. Lordship has seen how the case has been prolonged at each stage, Your Lordship. A proceeding which started in 2009, Your Lordship, 145, 146 proceeding is of a it ought to decide whether there is any public breach of peace or not. Not the title, not anything else, Your Lordship. In the meantime, they have filed a title suit. They did not contest. Ultimately, it was also dismissed, Your Lordship. There is no appeal against that. And now, by way of this impugned order, Your Lordship, the matter has been remanded on 2 grounds that they should be given a chance to cross-examine, and the petition that they filed for impleadment, that should also be given into. The learned appellate court is of the view that it is that a title suit, as if a title suit is being going on in the court below, Your Lordship. Whether there is any breach of public peace or not, that is the question that is to be decided. And so far as the title is concerned, it was a title suit, Your Lordship. They ought to have pursued it, Your Lordship. If it was dismissed for default, they ought to have filed an appeal or they have to go for a restoration of the suit. But they have not gone into, Your Lordship. And Lordship, the Honorable Supreme Court has said that once a matter has been decided by a competent civil court, Your Lordship, 145, 146 proceedings cannot continue, Your Lordship. 145, 146 is a temporary measure to prevent public peace, Your Lordship. If there is any sort of there may be public until it is competently decided by a court of civil law. Here is a case, Your Lordship. Their title suit is ultimately dismissed, Your Lordship, maybe due to default. but it is dismissed, your lordship. They have not gone into appeal, your lordship. Whether 145, 146 proceeding can still continue, your lordship. That is the case, your lordship. And the reasons given by the Honorable Court below for remanding back are totally unjustified, your lordship. Once the cross-examination was closed after giving several occasions, that order not put to challenge. Impleadment petitions were also rejected with
See,
loss.
it's okay. They have dismissed the title, so they have not challenged. But why you were pursuing them?
Lordship.
Why were you pursuing them?
No,
Why were you giving the evidence? You should have stopped them. The title should have been dismissed. You were the defendants there.
Yes.
Then why you?
No,
were
the court said that
producing
you furnish your evidence because their hair title is not being
That time
decided.
you got to have apprised the court. that
Hair title
should
is
have
not
been
being
dismissed.
decided. Here it was decided whether there is any breach of public peace or tranquility. The reports lordship has seen submitted by the police,
Yes.
your lordship.
Correct.
Maybe.
No.
2009 and 2025 it is disposed
Yes.
after 13 years, your lordship.
Lordship, firstly, I would just like to reply on that title suit aspect, Lordship. The right title of anybody were decided in that dismissal order.
It was not decided.
It was not decided in any favor, Lordship, firstly. Secondly, Lordship, they have got no legs to stand, and I would like to submit that they should fairly concede in this particular proceeding, Lordship, because of glaring, apparent, incorrect illegality of the impugned judgment, Lordship. I will substantiate the same before this honorable court. Lordship, it is their case. I will be pointing out from their petition itself. It is their case, Lordship, page number, Lordship, 17, page number 19. Lordship,
Left over. All the other matters will be left over. Will not give dates. Otherwise, you see how they're fixing today I had 2 courts, division bench, 4 matters, and they have fixed 33 cases with 10 hearings. If the matters will be left over, they will understand how to fix the cause, how to arrange the cause list. Sorry. Okay. Because we'll have to end somewhere.
Yes.
Lordship, the next item, I have item number 7.
Everything will be left over. If it is left over, then if I don't give a date, then they will know how to arrange the cost list according to a human being's capability, not according to a machine's capability.
Lordship, there is an interim order in item number 7.
It will be left over. It will remain in force. When the matters will be left over, everything will remain in force.
Just a small submission, Lordship. In item number 21, the matter was fixed today, but it has been wrongly listed with item number 19 and 20. As per the last order, it is reflected in the record also. As per the last order 22/4 of 26, the matter should have been tagged along with some other criminal matters. So,
But we have already segregated. Item number 20. Oh, acha. You take it up before the section. Outline.
Lordship, may I mention item 28?
We will not give dates. The matters will be left over.
Okay.
Lordship, page number 3. From page 3 of their criminal petition, Lordship.
Page 19 or 3?
So, no, first page number 3, Lordship, criminal petition.
Yes, page 3.
Yes, Lordship. In para 4, they said that they have purchased 6 kathas of land through registered deed in the year 2003, Lordship. And in para 5, it is their case. In para 5, they purchased 4 katha
in the year 2007. Total 10 katha, Lordship. Total 10 katha. In para 7, they have said, Lordship, what they have done, it is their case, Lordship. Out of that 6 katha, they sold 5 katha, 8 sarak to one, this Sonamia Borbhia, Lordship. And Sonamia Borbhia again sold his land of 5 katha, 8 sarak to them. That means the land remains same. Total land 10 katha remains same in the hands of the second party appellant, Lordship. What is the land, Lordship? The page number 5, this last portion of the para 7. Page number 5, last portion of the para 7. They have said that,
Yes, okay.
Lordship, the petitioner is the rightful owner and possession of a piece of compact land in one plot measuring 10 katha situated in Moja so-and-so, second so-and-so, dag number, this pata number 15, dag number 65 in the district of Kasar, east, house of Iskorali, west, Sonamia Borbhia, north, PW Road, south, Babu Mia, son of Tadamul Ali. That is their land, Lordship. As per their version, they have purchased. Although we have not admitted the legality of the sale deed, it was purchased from some of the sons of my uncle, and the uncle had 5 daughters. They have not sold the land to them, and one of the proposed seller, he was a minor at the time of the alleged deed. So, in respect of the title, this is not the forum to discuss the title. However, we have objection regarding that. Now, Lordship, it is their version that it is their land, 10 kotha. 10 kotha as per their case. Now, Lordship, they have submitted my petition. They have submitted my petition under section 190, that is in page 19. Page 19 of this criminal petition, Lordship.
Page
That's,
19, yes.
yes, it is my case. It is the translated copy. They have a typed copy, Lordship. What is the schedule of the land, Lordship? In the district of Kasar, so and so,
Yes.
covered by RS Pata number so and so, Pata number 15, dag number 65, quantum of land 16 katha. 16 katha. My case was of 16 katha. East, land of Tadamul Ali. In their case, in the east, house of Iskar Ali, Lordship, page 5.
Okay.
Lordship, page number 19 compared with page 5, Lordship. In west, land of the aforesaid dag and pata, in their case, in the west, Sonamia Borbhia. North, PW Road, it is the same, Lordship. And south, land of Babu Ali. So, my land is of 16 katha in my case, Lordship. Now, Lordship, I would like to bring your Lordship's kind attention to page number 37 and 38. Page number 37 and 38 was the order dated 28/3/25. 28/3/25, passed by learned ADM, which was impugned in our this criminal division before the sessions judge. What is the schedule, Lordship? I am fighting against two parties. One is the second party and other is the ADM. ADM is with them, Lordship. Because, Lordship, they have claimed that they are having 10 kathas of land, this purchased by sale deed, and ADM, what ADM declared, Lordship? Lordship pays this on the middle, Lordship. On the middle, Lordship. From the above, on perusal of the available materials on record, I am satisfied to believe that the DL is possessed by second party prior to filing of the instant suit, and in my opinion, the first party failed to prove the case, and hence I declare the possession of the DL in favor of the second party until otherwise decided by any competent court of law. Accordingly, the attachment order is hereby vacated. No ground why attachment order is vacated here, Lordship. No mentioning of the earlier report of the police, Lordship. Schedule. District Kafar, PS so and so, Moja, Tarapur, Part 4, RS Pata number 15, Dag number 65, land measuring 16 katha. It is my land, Lordship. What is this in my schedule? 16 katha, covered by, bounded by land of Tadamul Ali, so and so, so and so. It is the land which I put in my schedule of my petition. The ADM has declared this land to be of them, whereas they have not claimed. She is so generous, the ADM is so generous that they claim 10 katha, ADM gives 16 katha, not 10 katha.
Plus 6 kathas more.
Lordship, that what is to be seen by the sessions judge? Whether the order was correct, whether this court will say that this order is correct. This certainly I will come to the impugned judgment, Lordship, of the revision sessions court, Lordship. This order is palpably wrong on the face of the record itself, illegal, incorrect, and session judge has not decided any merit of our party. Session judge has not said that no, I am this petitioner is in possession. You are not. Not saying that. Session judge gives a chance to further cross-examine these three witnesses and decide according to law.
It's not required to decide on that.
No,
impleadment petitions.
No, yes, Lord. I would fairly submit. He was not this right in deciding the impleadment petition because that was not in our prayer also. In the claim petition, this revision petition is here. That part, Lordship, that part was wrong. So far as the allowing the impleadment petition is that, I would like to fairly concede that that part was wrong. But so far as the decision of the ADM is concerned, this declaring the possession of 16 kathas of land in favor of the appellant, it was palpably wrong. So the learned session judge was correctly right. I will come to the actual wordings of the sessions judgment, Lordship. So what it is done that within 3 months they are to be cross-examined. So now it is more than 9 months in the High Court. So they are challenging the 3 months.
I have given a stay here? No.
It stays there.
Oh, so there is.
There.
There is a stay.
Yes, it stays there. So now, Lordship, I will come to the judgment portion, Lordship.
Okay.
Judgment, Lordship. Page 56.
Page 56.
Before that, Lordship, page 54. It is their submission, Lordship. Page 54.
Yes.
First party has submitted that, second party of we claimed that 10 kathas of land. Our submission that revision is first party has submitted that the second party OP claimed to have purchased 10 kathas of land, and first party revision is filed an instant case involving 16 kathas which has separate boundary, but surprisingly the learned court below has declared possession over 16 kathas. Lordship, now page 56. Page 56, just above the para number 10, Lordship.
Yes.
The observation of the learned session judge. On perusal of impugned order, it appears that though the second party OP claimed to have purchased 10 kathas of land with separate boundary, but the learned court below declared possession over total 16 kathas of land involving the land of first party revisionists with separate boundary.
He has read it out. He has read it out.
No, not this portion.
He has read it.
Yes, of course. Not stressed upon. but
Not stressed, but.
yes, Lordship, fairly. So this is the
because
observation of
I
the,
have underlined it.
yes. Now, in view of the above position, clearly incorrect. What in para 11, he has also read it, that considering the entire facts and circumstances, I am not considered with the case is remanded back to learned court below to facilitate the first party to cross-examine the DWs within 3 months from today. The other party's Lordship, I do agree that so far as the impleadment petition is concerned, that should not have been taken care of, because it is not our case. We may say during argument also, but it is not in our prayer to set aside that particular order. Then Lordship, he says in para 13, Lordship, page 57, the impugn order dated so and so
Yes.
is incorrect and needs to be questioned, set aside. Now, my humble submission is that whether my learned friend can say that impugned order passed by the ADM was correct. Now, today, whether he can say, I will fairly submit. I can call a spade a spade. Impugned order of learned ADM was palpably incorrect, Lordship, because they are claiming 10 kathas of land. My case is of 16 kathas of land with different boundaries, and ADM has declared possession of them in respect of the 16 kathas of land of different boundary, not with their land. So, learned session judge has correctly come to the conclusion that the order of learned ADM was palpably incorrect, and it is the duty of the revisional court whether that is any illegality or incorrectness. He is not appreciating the evidence. Just on the face of the record, on the basis of the pleadings of the party, it appears that it is incorrect. Therefore, he has remanded the case. Not affected their right and my right. He has remanded the case for giving us the chance of the cross-examination, Lordship. That is the case, Lordship. In view of this position, my humble submission is that this criminal petition is liable to be dismissed. It is not a case of quashing or setting aside the order of the learned session judge. Learned session judge has not made any wrong. However, I would like to fairly submit that this court, while disposing this case, may not allow us in respect of this impeding part. This is we fairly concede. But so far as the other part is concerned, the giving us the opportunity to cross-examine the witnesses within a time frame that is rightly passed by the learned session judge. Lordship, in respect of this, Lordship, I'd like to rely on a few documents, this judgment, Lordship. One judgment, Lordship, of the Supreme Court, P. Sanjeeva Rao. More specifically, Lordship, para 13, 14, 15, and 16, Lordship. I'd like to rely on that.
Para 13, 14, 15, and
15 and 16, Lordship. So, because, Lordship, what is that, Lordship? Mainly the para 15, Lordship. The discovery of the truth is the essential purpose of any trial or inquiry, as observed in other earlier cases, Lordship, by three-judge bench. Thereafter, in 16, Lordship, we are conscious of the fact that they recall the witnesses as being directly nearly 4 years. After it was allowed to recall the witness after 4 years, Lordship. Even then, it was held that the fairness of the trial is a virtue that is sacrosanct in our judicial system, and no price is too heavy to protect that virtue. A possible prejudice to the prosecution is not even a price, leave alone one that would justify denial of the fair opportunity to the accused to defend himself. In this also, Lordship, the fair opportunity, for the interest of the fair opportunity, the learned session judge has given that he should be given time within 3 months
this witness should be cross-examined and then this pass an order as per law. And that also, Lordship, in respect of this 482, the power of the of setting aside also, I have submitted one judgment of the Honorable Supreme Court, more specifically para 6, Lordship.
See, this is relating to 311, I believe.
Lordship?
That this Sanjeeva Rao.
Yes, Lordship, 311. So when the witness is being disallowed, after 4 years, the witness is allowed to recall and for the purpose of cross-examination, Lordship. And here also for the purpose of cross-examination, Lordship, this was allowed, Lordship. And para 6, Lordship. So far as the question regarding crossing is concerned, Lordship, it has been it is time-tested principles, Lordship, that it has to be used sparingly, Lordship. And another judgment I would like to submit here, Lordship. This is one for the summer. This is the time-tested principle, Lordship, even from the Bhadalnal also. This is the time-tested principles under for invoking the jurisdiction under section 482 of the CRPC. It is, Lordship, in the last page, Lordship, page number 6, that is para 20. The 4 steps are being shown, Lordship, para 20.
Okay.
4 steps are given, that this is the 4 steps. Step 1, 2, 3, and 4. Lordship, in 4, Lordship, step 4, whether proceeding with the trial would result in an abuse of the process of the court and would not serve the ends of justice. Thereafter, if the answer to all the steps is in affirmative, not either of the 4, all the steps, that means these 4 steps, all 4 must be satisfied. Here, Lordship, I would like to specifically point out the point 4, whether it is, if allowing, whether it will be an abuse of the process. Rather, if the judgment of the learned session judge is not allowed, it will be abuse of the process. It will be abuse of the process of the law because of the fact that the pleadings stage 16 kathas of land, they claimed 10 kathas of land, and the learned ADM this gives 16 kathas of land. It will be an abuse of the process, Lordship. Therefore, to prevent the abuse of the process, learned session judge has rightly passed the order allowing us for cross-examination. That is my humble submission, and I would like to submit that your Lordship may revise the session's judgment, which that particular direction may not be favorable to us in respect of the allowing the impleadment petition, but so far as the cross-examination is concerned, my humble submission is that is to be upheld by this honorable court.
Reply?
Yes, wait. Learned parent has made a submission that the title suit has not decided title of either of the parties. That is not a correct statement, Your Lordship. When a title suit is filed, Your Lordship, I assert that this is I have a right title and possession over this land. And it is for me to prove that I have a valid right title and interest. If the title suit fails for any reason whatsoever, it is me, I have failed to prove my right title and interest over the suit land. It is not a case, Your Lordship, that the title suit was dismissed without any reason. The court has, honorable court has held that several dates have been given for them to give the evidence. They did not adduce any evidence. Therefore, the title suit was dismissed for non-prosecution and for default. But the reason is that they have not adduced evidence. If I file a title suit and if I don't give evidence, Your Lordship, ultimately I have failed to prove my right title and interest, and therefore the right title and interest has not been decided in his favor, Your Lordship.
I am not saying.
No,
I'm not saying that right title is decided in my favor.
You cannot say also. You cannot say also.
You also cannot say that it was decided in your favor.
Yes,
it was counterclaim.
Make me a respondent, Your Lordship. No. When you are asserting that you have right title and interest, and I am the defendant in the case, if your title is not established, Your Lordship, it means that I have a right title and interest, Your Lordship. That is how the title suits are decided, Your Lordship.
ADM cannot assert that.
No. If he's aggrieved, if he's aggrieved by this order, Your Lordship, he ought to have filed an appeal before against that order.
It is a dispute of possession, Lordship, before ADM.
Now, Your Lordship, the honorable court below has given that there should be given chance of cross-examination. Why so benevolence, Your Lordship? The learned ADM has time and again held that several dates have been given.
But you are given 4 kotas, 6 kotas extra.
No.
Why is the ADM so benevolent?
No. It may be because the ADM might not have seen the schedule of the land. We have never said that we have 16 katas of land. We are saying 10 katas. And he is also admitting that 10 katas, which we are saying to be ours.
No, not admitting. Not admitting. It is their case. I have placed it.
Let me submit.
No, not admitting. No, I am not admitting, Lordship. I am not admitting.
Lordship, I
He
submit.
has correctly held that he has correctly held this judgment cannot be set aside. That ADM's order has to be set aside. When there is a 16, when you are claiming 10 kathas, he is claiming 16 kathas, and
out of these 16 kathas, Your Lordship,
ADM had to give him extra, extra.
No, we are also not in possession of extra kathas. No. He is also not in possession of
I am totally in possession of 16 katha.
I am not asking, Your Lordship. Now the case is that, Your
This
Lordship,
court cannot divert this now, dissect the land.
let me submit, Your Lordship. He has claimed that there are 16 kathas of land which he ought to have the possession, Your Lordship. Now we have given our details that we are having this 10 kathas of land, Your Lordship. Now he said that he admits to the point that with this 10 kathas of land he is demanding, because he has filed an application saying that he is ready to give back the money to us if the land is given to him, Your Lordship. Therefore, this 10 kathas of land definitely falls within the 16 kathas, Your Lordship. The petition that he had filed before the learned court below, he has admitted to the fact that we have that 2 sale deeds have been validly executed, and he is ready to pay back the money for this 10 kathas of land, Your Lordship. That is his admission. That is his case also, Your Lordship. It is not that. Otherwise, he should ought to have gone for cancellation of the title by way of title suit to cancel the sale deeds, Your Lordship. Then he ought to have proved his right title interest, which he has failed.
Whatever it is, you see, maybe he doesn't have a case. Maybe he has no right over. He was a minor at the time.
No minor. How he was a minor?
He was a minor.
Factual things cannot be, Lordship. This is not a case that.
Lordship, one of the seller, Lordship, one of the sellers, and five daughters.
Therefore, he has filed a
That
title
is
suit,
not an issue, Lordship. I have.
Correct. That is not an issue.
That is not an issue, Lordship. I have just because the title is not an issue here, or before ADM also. It is only the possession. It is only on that aspect. Therefore, Lordship, now this court or the learned sessions court cannot correct and dissect the schedule land that you will get 10 katha out of this schedule. Cannot. It has to go to the trial court. So therefore, from this court also, the learned session judge decision is to be upheld, and the trial court will decide ultimately after cross-examination what is the quantum, whether they are entitled or we are entitled, Lordship. Our case is that we are still in possession. This by virtue of this paper order, they can't affect us possessing the rightful this land, Lordship. Even then, as because this order was passed illegally, even beyond their pleadings, I am not admitting that we are giving this 10 kathas to land. I am saying about their case that they pleaded that 6 katha they purchased, 4 katha they purchased. They said that their land is total 10 katha. This is that. I am not admitting here. I am totally denying that we are now still possessing, Lordship. Only here in this case, Lordship, there is no question of title, decision of title. Only the question is that whether the learned session judge has rightly passed the order or not. So in that context, I said that learned session judge has rightly pointed out.
Orders are wrong.
Yes,
Both the orders are wrong.
Now, Lordship, yes, section 145.
Yeah, I'm saying that we will conclude at this today. What do you want to say? Anything else?
Lordship will fix it on another day.
No, no,
No, no,
I'll
Lordship.
conclude it.
Yes. What is it? Why section 145, 146 proceeding here, Lordship? Lordship knows it very well.
It has taken a very long time. It is true. Again, remanding it, I was agreeing with him. Again, remanding after 9 long years.
2009 and
This is not
2026.
correct.
Today is
And
15
again, there's
16 years.
point that title suit was already
Dismissed.
You have a point.
He had a very good case had he not filed the title suit. Once you don't file title suit, yes, the party, the CJM, ADM court can
But
decide.
I'll balance everything and then I'll pass an order.
No, Lordship can do
According
that.
to your
There is
submission.
absolute, and we are also not claiming 16 katas, 10 katas of land is in our possession. No, the court has also not, it is not that by way of that order we will get 16 katas of possession. That is also not the case, Your Lordship.
We will not decide.
Oh,
Now this is under.
this is a separate
482.
boundary.
So I will use only 482,
Yes, Lordship.
not more than that.
Yes, and Lordship, I'll
Yes.
rely on two judgments of the Honorable Apex Court, Your Lordship. It says that once a civil court has taken, has a
Decision.
decision, Your Lordship,
Definitely.
there
It
is not.
always there. That is why my first question.
Yes. Their case would have been, had they not filed the title suit, Your Lordship. Title suit filed dismissed that did not go for appeal, Your Lordship. They have not challenged that order. And they want to prolong this. See how they have prolonged, Your Lordship. They have also filed a petition that it should be transferred to another judge, Your Lordship. That was also transferred to another judge also. If I'll just rely on Lordship, first to get this 1985 1 SCC, Your Lordship. Ram, in this case, Your Lordship, it is a very short judgment, Your Lordship.
Yes.
Paragraph 2. Challenge in this application is to the order of the Allahabad High Court refusing to interfere in its revisional jurisdiction against an order directing initiation of proceeding under section 145 CRPC and attachment of the property at the instance of respondent number 225. Indisputedly, in respect of the very property, there was a suit for possession and injunction being titled suit number so and so filed in the court of civil judge at Balia, wherein the question of title was gone into by the judgment dated so and so. The said suit was dismissed. The appellant was the defendant in the suit seat. According to the appellant, close relations of respondent number 2 to 5 were the plaintiffs, and we gather from the counter affidavit filed in this court that an appeal has been carried from the decree of the civil judge, and the same is still pending disposal before the learned appellate court. The assertion made in the petition for special leave to the effect that respondent 2 to 5 are close relation has not been seriously challenged in the counter affidavit. When a civil litigation is pending for the property wherein the question of possession is involved and has been adjudicated, we see hardly any justification for initiating a parallel criminal proceeding under section 145 CRPC. There is no scope to doubt or dispute the position that the decree of the civil court is binding on the criminal court in a matter like the one before us. Counsel for the respondent number 2 to 5 was not in a position to challenge the proposition that parallel proceedings should not be permitted to continue, and the event of a decree in the civil court, the criminal court should not be allowed to invoke its jurisdiction, particularly when possession is being examined by the civil court and parties are in a position to approach the civil court for interim orders such as injunction or appointment of receiver for adequate protection of the property during pendency of the dispute. Multiplicity of litigation is not in the interest of the parties, nor should public time be allowed to be wasted over meaningless litigation. We are therefore satisfied that parallel proceedings should not continue, and the order of the learned magistrate should be quashed. We accordingly allow the appeal and quash the order of the learned magistrate by which the proceeding under section 145 has been initiated and the property in the dispute has been attached. Instead of following this case, they ought to have filed a title suit and
that referred case was of this decision on merit, decision in respect of this possession lordship. That was in that case, the learned civil court has decided the title and possession of the party, and thereafter the 145 this one was filed. In that context of the matter, that has been observed.
Title suit has been
that is not
dismissed,
applicable in this particular case.
The dismissal of title suit itself indicates your lordship.
No.
Lord, they hope
No.
Lordship,
That is not made.
order passed by in the title suit.
Not on May.
Several dates have been given to give evidence. Your Lord, they don't go and give evidence.
Only due to default, not on May.
No. several dates have, it is not that
No.
they have suddenly not appeared. They were appearing and taking.
No
time.
issue was decided. No issue was decided. Even of title or of possession, no issue was decided.
Yes.
Now, this second decision also on the similar line, your lordship. There also, your lordship, as a suit was filed, your lordship, the court said that since the suit has been filed, your lordship, proceeding under section 145, 146 should not constitute. Paragraph 4, your lordship. The petitioners have already filed a suit for injunction in which ex parte interim injunction has been granted by the civil court Faizabad, so and so. Once the civil court is seized of the matter, it goes without saying that the proceeding under section 145, 146 cannot proceed and must come to an end. The inter se rights of the parties regarding title or possession, whatever it, your lordship, are eventually to be determined by the civil court, your lordship. In this view of the matter, and without expressing any views on merits of rival claims, we dispose of the appeal, your lordship. And following this, your lordship, I have given a judgment of the Andhra Pradesh High Court also, your lordship. They have also said that if matter is ultimately decided by a civil court, rightly, wrongly, your lordship, then 141 and 146 proceeding cannot again go into your lordship. Simply a matter has been prolonged since 2009 and we are 2000, till date they are not filing title suit, they are not claiming their title and they want to prolong this 141, 146 proceeding on. This is their case, your lordship. And whereas
it is our land, we are possessing. You file your case.
No, no.
That is so. You are not getting the land.
You are claiming right title interest.
We are possessing. We are possessing since the days of my forefathers. So if you are, you have purchased the land, you are. Who has prevented you to go to the civil court?
I think nobody can go to the civil court.
That's
That's why they are pursuing this matter.
So, your lordship, the impugned order is required to be satisfied, your lordship, in the interest of justice.
Let's see.
Now, I have one instruction that they might have filed, recently they have filed a title suit again, your lordship. They have filed a title suit and our party has got a notice and they have also appeared, your lordship. If
maybe I.
Yes,
I
lordship,
have to
I'll take,
contact.
lordship will fix it on one day, your lordship. I'll just, if title suit they have already filed, your lordship,
Yes.
that proceeding will be closed.
Definitely.
I'll
Not
just
fix it for CAB then.
Yes, one day only, your lordship, day after
One day.
tomorrow.
Maybe,
Monday.
maybe lordship, because
they have filed
even
a
then,
title suit.
even then, lordship, even then, when during pendency, if civil suit is supposed filed, lordship, then the trial court may say that you contest in the civil court. Now, lordship, they have decided, the ADM has decided the possession in favor of one party.
No, but we can pass that order.
Yes.
That order, whatever order this court will pass.
Yes.
If there's a civil suit pending, then we can take that into account
Yes,
and pass.
lordship.
Only one day.
Yes.
One day. If a title suit, if
Yes.
civil suit is filed.
Maybe lordship. I will also take instructions.
The mere prestige of judicial time, your lordship. 16 years in an MR case, your lordship.
System.
Actually, it could have gone for settlement also.
Question of settlement, we have.
Only on one point, I'll keep it pending. no?
Yes. Next you can.
Learned counsel, Mr.
MH Losko.
MH Losko for the petitioner and learned counsel, Mr. Darakula for respondent number 2 and learned additional PP, Mr. RJ Borua for the respondent state. Full stop. Before passing any judgment, this matter is kept for a clarification. If any civil suit has been filed by the respondent against respondent relating to the same plot of land. Okay. List on, this matter as part of 29 May. Part of this. 29 May. I'm so sorry today again. We'll give you a date.
Yes, short date.
Argument 2 PM.
Day after
2 PM
tomorrow,
what
2 PM. Day after tomorrow, 2 PM.
Not day after tomorrow.
19.
Only to you, others will be left over, huh? Only to you will.
Yes,
give
my
your
lord.
date. 19, 20, 21.
No, 19. Yeah, take matter, take matter.
But somebody wanted 20 to be separated. Okay. Okay. Okay, let it be left out. They have gone to the section to get the matter separated. The other party. I don't know. You please
No,
mention.
no, I'm up to 23. 23.
Oh, 23.
Oh, sorry, 19, other,
Lordship,
23, madam. 23.
Yes, yes.
Lordship, our matter, Lordship, can it be first week of June, Lordship?
First week, sure. First week of June, yes.
28.
Yeah, on first week of June.
Obliged.
Yes.
23, my lord. I am sorry, my lord.
Okay,
Not 19, my lord.
Take 9. Huh? 23 to take assembly.
Only 19.
You have to mention, I think. I'm so sorry, you will have to mention. Or 19,
23 item number. Oh,
No, madam.
you were not present when we.
I am here, my lord.
Yes, you were here, but at that time you were not there. I'm so sorry.
My lord, can we please?
Please mention it before somebody. And then on that day, if I cannot take up, I will fix it at 2.
All right. Then that day after tomorrow, I will mention in the
Yes.
morning.
But you will have to mention before Justice P.J. Swetia.
Yes.
And then on whichever day it's fixed, if I cannot take up, we'll fix it at 2. Immediately we'll fix it at 2 on some other date.
Right.
My lord, item number 30, 31, and 32, there's an interim order that may be extended.
No,
And so
it's
is it-
leftover.
My-
Leftover. Exactly on the date of mention, when this case will come up, maybe we won't be able to take up. But on that day, I will see you, no? So I will see you and I'll call you. Any one of you, I'll call you if it is relating to this case. Then I will fix a date at 2 p.m. Like
Yes.
today, I have heard one case at 2 p.m.
Yes.
because they have been coming and then
Yes.
we could not hear them out. So that same day, I think you were also present on that day.
Yes.
We fixed it at 2 and yours we didn't fix it at 2.
Right.
So